Your Lordship, I beg to mention item 7.
Hearing,
Yes, Your Lordship.
criminal matter.
Yes, Your Lordship.
Yes.
Maybe adjourn for something.
On behalf of Mr. Mao,
Yes, Your Lordship.
madam, you're the legal aid counsel.
Yes.
When can we fix this matter? When can we fix this matter? These are criminal appeals.
Lordship, any date?
Yes, madam, give us a date.
After 2 weeks.
Suggest a date after 2 weeks.
First of February? Sorry, sir. First of February.
I have it on 8th of February. Is it okay?
Yes, my lord.
A prayer for adjournment has been made on behalf of 3S Mao, learned counsel for the appellant. Full stop. Also heard Miss Nikita Dangan, learned legal aid counsel. Full stop para as agreed to by the parties based on 8-2 for hearing.
Much obliged.
May I please, Lordship, this case is Lordship, against the conviction, Lordship. Kindly see the conviction order, Lordship. This page number 80, page number 80, conviction order by the POCSO Special Judge POCSO, convicting the accused for 12 years. In this case, the only ground is,
Now, why a revision?
Lordship, this procedure not followed.
So
That
you
is
cannot take up this as a ground in the appeal.
This in that event, Lordship, this revision may be converted into the appeal.
No, revision cannot be converted into an appeal. Appeal can be converted into a revision. Appeal has its own procedure in it to frame grounds. How is the revision maintainable?
Lordship, the only issue is, Lordship, here.
No. Is there any bar for taking up the grounds which you are taking now in an appeal? In an
Yes.
appeal?
No, there is no bar.
Then why have you come with a revision petition? It's a straight cut of a conviction order which is appealable.
It is available, but in revision also it is not bar. Revision also it is not bar.
Why? If appeal is provided in the
Can-
statute?
Understanding, kindly see, Lordship. Yes, sir. Kindly read the this.
See, this is the final.
Section is 401 and 3.
No, that is okay. Mr. Tapak, there is no dispute that this is a final order.
Under 401, the
Mr.
Lordship.
Tapak, is there any dispute that this is a final order of conviction?
Yes,
No
fine.
dispute.
This
the
is
final order.
Final order of conviction, yes.
So the appeal lies.
Appeal lies, that is there.
In an appeal, you will get all the avenues. You'll get a bigger platform to argue. File an appeal. Madam, what do you say?
Yes, Your Lordship.
I am praying for Lordship, remanding back the case to the trial court, Lordship. That is,
It's up
under 401, I pray
to
for
you.
Lordship.
It's up to you, but show us
Because without,
how a revision is maintainable.
kindly see, Lordship, 401, Chairperson, this court has the power and jurisdiction to, Lordship. 401 and 397.
Yes,
May I read the content?
just a minute.
As per the 397, Lordship.
Yes,
The High Court or any sessions judge may call for to examine the record of any proceedings before any inferior court situated within its or his local jurisdiction for the purpose of satisfying itself or himself to the correctness, legality, and propriety of any finding, sentence, or order recorded or pass, And as to the regularity of any proceeding of this inferior court, and may then calling for such record, direct that the execution of such sentence or the order is suspended. If the accused is in confinement, that he be released on bail on his own bond pending the examination of record. In this case, it is not barred also in the after conviction also, this revision lies. And before this is just 401 is wider. High Court power of revision, see. 401 CRPC.
No, we have failed to understand what is preventing you from filing an appeal?
Because lordship, in this case required further evidence. That is the issue here also.
Isn't there a
court-
provision, isn't there a
the trial
provision,
court has
isn't there a
not
provision in the CRPC to adduce further evidence
Yes,
in an appellate court?
yes. Under the 401.
No, you're not answering. First, answer the question.
Yes, yes.
Where?
Under the 401 CRPC, lordship, this court has the power to apply 386, 389 and 390, 391 CRPC, by which this appellate court can either take evidence, additional evidence, or remand it back to the trial. court.
Appellate court, not a revisional court.
Not, this revisional court has power to exercise as an appellate court, as per this provision of law. This apply the power of appellate court, as per the 386.
No, when there is a clear-cut provision of an appeal, what has prevented you from filing an appeal?
Appeal is to my understanding.
No, why haven't you filed an appeal? We
Lord-
are not very interested with your understanding.
To my understanding, lordship, appellate court is when there is a legality and illegality of this order is raised. When the evidence is completed, in that case, the binding opinion of this trial court is examined by the higher court. In that case, appellate court is required. The matter required to be raised before the appellate court. When the
Is your submission supported by 374? Read 374. Is there any restriction of such kind in 374?
374, 374, there is no restriction, but 401 also, this honorable court has the power.
When do you fall back on a revision? When do you invoke 397 and 401? Tell us.
397.
When do you fall back? When there is no
that
appeal?
That is, to my understanding, that come into play when the trial court does not completed the trial proceeding. When trial is completed, the all evidence is taken, in that case, appeal lies. But
Here-
when the procedure, there is a procedure irregularity.
No, here has the judgment been passed or not?
Judgment has been first, but procedure not followed. That is the issue raised by the procedure, because the evidence.
This
has
cannot
been
be a
not-
ground,
Evidence
this-
not completed.
This cannot be a ground in the appeal.
That cannot be,
That cannot be a ground in the appeal.
no, that cannot be a ground, because that can be a ground, but 401 also, 401 CRPC also, this court has a jurisdiction to either take evidence before the appellate court or remand it back to the trial court for fresh evidence under 401 CRPC.
But when the statute
Court,
itself provides for an appeal,
Even also court may not record the evidence, suppose. If
Yes.
it is as per court, if it is not a necessary
Yes.
or required witness.
That's-
So
that
it
is-
may be
that
skip
is-
off.
that is-
So
that
what
is-
is there?
That is this. That is
You
discussion
can
of-
raise all these issues most probably in the appellate also.
because this conviction without this hearing the my issue is 315 of CRPC, because accused person is the, I have taken, accused person is the competent witness as per the CRPC, 315. The accused person has filed application under 315 CRPC for taking stand for defend himself as evidence, witnesses, defense witnesses.
In that
But
case,
that
there
is-
may be a
that
ground
has-
for review, remark.
Only that is the ground. The court has not allowed him to defend himself. That is why this case has been filed in the form of revision order has been passed because there is no bar under 397 and 401 CRPC. Even if Lordship, this final order is passed, this court has a revisional power to redirect or remanded back the case to the trial court for taking fresh evidence to complete the evidence as per law. Kindly, Lordship, this is the page number 53, annexure 10. This is the application filed by the accused person. Two defense witnesses has been, including himself, the accused person himself. Only one of the one of the defense witnesses has been examined, but he could not be, this appellant could not be examined because he's the accused person here. This is a violation of the 315 of CRPC. Where court has clearly said there's a statutory provision under the law that it can be a competent witnesses. This impugned order is not on merit, passed not on merit. But
Yes, madam?
Yes, your lordship, if your lordship will see 401, your lordship,
Hmm.
which clearly bars that if there is any proviso for appeal, your lordship, 401 may not lie. The revision under 401 may not lie. With regard to 397.
From where are you making this submission?
It's in the statute, your lordship. Will come to 409, subsection 4, your lordship. 401, your lordship.
401 subsection?
4.
What is this? Read it.
Where under this code an appeal lies and no appeal is brought, no proceeding by way of revision shall be entertained at the instance of the party who could have appealed, your lordship.
Statutory bar.
Yes, this clearly bars, your lordship. With regard to 397, your lordship has rightly pointed out that if there is no proviso, for instance, if they have appealed before the session court and even the session court has appealed the conviction, your lordship, they have no having no other option, your lordship, then 397 is when they can
When
approach
there is
the
no
high court.
provision for any further appeal, we may entertain a revision.
Revision, your lordship.
Okay. But here the appeal is provided
Yes,
and appeal will lie in the High Court.
Yes, also your lordship will see the rules of the Guwahati High Court, your lordship. The conviction is for 12 years and therefore the division bench appeal in the division bench for
That's right.
conviction
That's right.
within 10 years. Therefore, your lordship, if they can withdraw this petition and file an appeal.
Yes, up to you.
yes, appropriate order may be passed. I will withdraw the case. And
Why
file
did you
fresh.
make all these submissions then?
I'll file fresh.
What was the necessity of filing,
Matter, Lordship, one thing that can be done, matter may be for tomorrow. I will see and
there is no question. We cannot waste our time. You may have a lot of time. We don't have that much of liberty.
I may
There are many counsel and many important cases.
maybe allow to withdraw the case and with the liberty to file fresh.
Should have made the submission at the first instance on our pointing out. Why did you wait for the turn of your colleague? Unnecessary. The instant petition has been filed by invoking the provisions of section 397, brackets 401 of the CRPC against the judgment dated so and so, full stop. It is, this court has Ms. Ginny, learned additional PP,
Yes, Your Lordship.
has however pointed out that there is a statutory bar under section 4014 inasmuch as against the judgment in question, comma, there is a provision for appeal. Full stop. See further by referring to the Guwahati High Court rules, comma. See further submits that since the sentence is more than 10 years, comma, the appeal would lie before a division bench. Full stop. Para. We are of the opinion that apart from the statutory bar, comma, the avenue for projecting a challenge in an appeal would be much wider, which would be in the interest of justice. Full stop. Para. At this stage, 3. Tapak, learned counsel for the petitioner, submits that he would like to withdraw this petition, however, at liberty to prefer an appeal in accordance with law. Full stop. Para. The petition is accordingly dismissed on withdrawal with liberty as prayed for. One. Tagum. Mr. Tagum, where are you? Mr. Kamduk, you are for the land management.
Yes, Lord. In fact, my lord, I was informed that he'll be seeking time for this case. But he,
But there has to be some request. You
Yes.
cannot presume that
Ye-
they'll seek time.
yes, sir.
Why is it for orders? You have filed, this is a writ appeal. More than 1 year time has elapsed.
So this is
Not yet taken. 7 and 8 press service.
My lord,
You're-
extremely sorry, my lord.
Yes,
I
you're
was supposed to take fresh step, my lord, in responding of.
7 and 8.
7th, my lord. I'll take, my lord, due to some communication gap, my lord. 3 weeks time I will grant.
But this matter is pending since 22. Why
My-
3 weeks? You take steps by tomorrow.
I'll take 3 weeks, my lord. For taking about within 2-3 days, I'll take.
No, not to by tomorrow.
My lord,
Office note dated 21/20/24 reflects that fresh steps for service of notice upon the respond number 7 and 8 have not been taken. Full stop. 3. T. Tagum, learned counsel for the appellants, is given a further opportunity to take fresh steps upon the said respond number 7 and 8 by registered post with AD. Full stop. Steps, however, has to be taken by tomorrow.
my lord.
Full stop. 3. D. Kamduk, learned standing counsel land management is present.
Deeply.
Much obliged.
Yes.
Service upon private respondent number 2, we have taken a fresh steps on previous appeal.
Service is complete.
May it please your lordship. Lordship, on the last occasion, the notice was to be served through the PP's office, your lordship. However, the entire brief is with my learned colleague who has.
No, there is a note of 20th of January by the officer in charge of the concerned PS at Changlang district. Stated that the notice has been served. How many respondents are there, Mr. Roland?
One Lord, sir.
No,
That's
two
what I-
respondents. Two respondents.
Yeah,
State and the other one.
yes, PPN.
Okay.
State and all.
Except for. पैसे नहीं चाहिए क्या? हम copy देते हैं, अपना economic करते हैं. See in the office note dated 21/2024, which refers to a communication from the officer in charge, comma, Manmao Police Station, issued to the APP, whereby it has been stated that the respondent number 2 has been served, full stop. The respondent number 1 is represented by Ms. Jeannie, the learned APP, full stop. The service is deemed to be complete, full stop. IA for what?
IA for condemnation, Lord, sir.
Condonation.
There is a delay of 74 days in filing connected activity.
Yes, anything?
Yes, Your Lordship, as far as even the IA is concerned, Your Lordship, if the service has been completed under section 440 of POCSO, Your Lordship may direct the registry to appoint a legal aid counsel, Your Lordship, for the victim.
No, yes, that may be for defending the case. Now, at the point of condonation of delay, do you have any objection?
I don't have any objection to that.
Hertz, Sri K. Lolan, learned counsel for the applicant in this application filed under section 5 of the Limitation Act for condonation of delay of 76 days in preferring the criminal appeal against the judgment and order dated so and so, passed by so and so. Full stop. Which paragraph? Sri Lolan has referred to the averments made in paragraph 6 and 7 of the application to explain the delay, full stop. Para. Ms. Ginny, the learned APP, submits that she will not have serious objections
Yes.
in principle as the matter, as the appeal is against an order of conviction. Full stop. See how it submits that in case the victim is, when the victim does not engage a counsel, comma, a legal aid counsel may be appointed, full stop. The said respect of the matter would be considered at the appropriate stage, full stop, para. Considering the reasons cited and also taking into account that the appeal is against an order of conviction, comma, the delay of 76 days is condoned. Full stop. I accordingly stands allowed. List the appeal for admission after 2 weeks.
Deeply.
Deeply obliged.
Wait, please, your lordship. Lordship, I am legal aid counsel for the appellant. And as per the direction of this honorable court, I have filed a memo of appeal. Order dated 31/7/2023. This honorable court has directed to appoint legal aid counsel and preparing memo of appeal. So accordingly, I have filed memo of appeal.
Okay, we need to admit this or what?
Yes, Your Lordship, a small point that Your Lordship may consider, Your Lordship. Even though this is a jail appeal, Your Lordship, taking into consideration that the accused was in the jail the whole time, Your Lordship, there is a delay in filing this appeal, that may be without filing an application for,
Will not
Delay?
insist on the delay.
yes. However, my submission that there is a delay, which I don't have any objection to, but then it may be reflected in.
Madam, your name?
My name is Jaya Doji.
Jaya Dorji.
Yes,
Heard Miss Jaya Dorji, learned legal aid counsel,
yes,
who has been appointed and appears for the present appellant. Full stop. The instant appeal has been filed under section 374 within bracket 2 of the CRPC against an order, against the judgment and order of so and so, whereby the appellant has been sentenced with how much?
sentence for life.
Like,
Sentenced with life imprisonment, with RI for life. RI
Yes,
for life. Any other thing? Outside of, or and in default side of. Full stop. Para. Miss Jeannie, the learned APP, however, points out that if the appeal is strictly construed, comma, it appears to be barred by time, full stop, para. And para, na. She however submits that she would not seriously object to admission of the appeal by condoning the delay, full stop, para. Considering that this appeal is preferred through the legal aid counsel by the appellant who is in jail, comma, this, we are of the opinion that the consideration of delay won't be a hurdle for admission of the appeal. Para. Accordingly, the appeal is admitted. Call for the records. Madam, for Ms. Jeannie, learned APP, is accept notice on behalf of the respondent number 1. Let steps for service of notice upon the respondent number 2 be taken through no, steps for service of notice upon respondent number 2 is required to be taken
yes.
through the concerned police station, which is to be routed through the office of the learned PP Arunachal Pradesh. Full stop. Steps within 3 days. List after 6 weeks, along with service report and report on receipt of the records.
Also, Your Lordship, it may call for the LCR, Your Lordship.
Also, admit report.
ambulance.
Admit call for the records. Report. Admit report. Call for the records. Item 5, legal aid counsel. Who's the legal aid counsel?
Uh,
Anyone has been appointed?
Your Lordship.
Legally counsel. Somebody has to be appointed.
Yes, Your Lordship, the registry may be directed.
Yes. LCR, the appeal was admitted on 1/8/2023. And the LCR, which were called for, have been received, full stop. Para. There is an office note with regard to the fact that the respondent number 2 was stated not to have been found in the given address. Full stop. In any event, comma, there will be requirement of a legal aid counsel to defend the said respondent number 2, full stop. Para. Registry to take appropriate steps for appointing a legal aid counsel,
Yes,
and the matter be listed after
3 weeks, Your Lordship.
4 weeks.
Deeply.
There's LCR, no? In the meantime, comma, registry may also prepare the paper book.
I am for the appellant in this case. And in this, I am seeking for condonation of 32 days delay, Your Lordship.
First time it has come.
Yes,
First time.
yes, first time.
Yes, madam, only issue
Notice
notice.
has been, no, notice has been issued.
Notices were issued.
Your Honor, I'm for the respondent number 4.
4.
Yes, today I have filed a couple of numbers.
Yes, anything you'd like to say?
Yes, Your Honor, I will be given some time to go through that, the IA also.
Okay. Oh.
Your Lordship, in that case, 1 week time.
Hmm?
It will be listed after 1 week in that case.
1 week, how much time?
2 weeks.
2 weeks, okay. What is your name?
K. Taja.
Ketaza, heard. Sri Ketaza, learned counsel for the applicant. Also heard. Ms. Wangmu,
Yes, ma'am.
Learned-
Wangmu.
learned your APP. Oh, this is an appeal.
Yes.
ma'am.
That
I'm
is-
Learned
from
state counsel.
123 minor.
Full stop. Your name?
A Bodo. A Bodo.
Para Sri A. Bodo. Learned counsel submits that he has filed wakalatnama on behalf of the respondent 4 today and prays for some time to obtain instructions slash file objection affidavit. Full stop. Para. List after 2 weeks.
Oblige, Your Lordship.
You are for 1, 2, and 3.
Yes, ma'am. May I please, Your Lordship? This read appeal, Lordship is against the order of the Learned Single Bench.
Your smile says something else, that you are not ready today. So she is ready, court is ready. So we'll drag you to be ready.
Well, and quite apart from that, my lord, the subsequent advertisement pursues to subsequent advertisement issued by the ministry. My lord, the progress of that is also required to be, my lord, is certain also, my lord.
We have not understood.
My lord, first advertisement was cancelled due to some infirmities, my lord, the mistakes, and thereafter subsequent advertisement was issued. And in pursuance to second advertisement, my lord, the recruitment process was initiated, my lord.
Yes.
And status of that recruitment, my lord, the process is also required.
Madam?
later.
Again?
This is something which I don't think would require much time. In that case, matter may be fixed on Monday, Lordship.
And he is also
It-
one of the, my lord, the candidates in that.
He has got at least 4 days.
No, did you apply for this in the subsequent
Yes.
recruitment?
Yes, I
Yes.
did.
You have.
Yes, I have.
Was there any protection given by the court without?
No, no, my
nothing.
lord, no, no, my,
No.
no, my lord. So
Without-
far as I know, Lordship, even call letters have not been issued till now, even after a year. After more than a year, call letters have not been
Since
issued.
protection has not been given and we are in the appellate stage,
Yes,
if they have already gone ahead with the second advertisement where you have also participated,
Yes.
are you really interested in the first one?
Yes, Lordship, because I was selected, Lordship. I'm not challenging just the advertisement, Lordship. I was selected, Lordship, in the first recruitment process.
What-
Everything was over,
What is
Lordship.
the grounds shown for cancellation?
There is, Lordship, there is the thing, Lordship. And initially they have said that the department, so to say, the Northeastern Institute of Folk Medicine, that was to be renamed as Northeastern Institute of Ayurveda and Folk Medicine Research. So the nomenclature, change in nomenclature was one of the reasons they cited.
No, that cannot be a reason for,
There is what, Lordship. And another, during the course of the writ proceedings, they have come up with another ground saying that there were some infirmities. But what infirmities are there? There is nothing, Lordship. That is there.
what have you cited?
Malad,
Okay.
cancellation was due to malad the leakage of the malad confidential malad.
That also, Lordship, I have that.
Malad, the examination was conducted at Shillong, malad. And malad, it has to be sent to the malad the selection committee in confidential malad in the seal envelope, malad. But it was sent in the open malad email, malad. So therefore, everybody malad exists the malad confidential. Thereafter, malad.
Have you stated all this in the affidavit?
Yes, malad.
No, Lordship, it was not stated on the affidavit that there was a communication,
Administrative reason we have stated.
Lordship. What they have stated
You
is,
have the records.
No, malad.
You get the records. If your record supports your view, then it's a different matter, but will not allow you to improve your case subsequently. That you become wise later on. Whatever you thought of was the reason has to be there in the records.
Yes,
It-
malad.
It may not be in so many terms.
There
in
were
the
so many
reviewed order.
correspondence made between the ministry and the malad the conducting the malad department where the recruitment has to be done malad for manpower. Malad. And malad quite apart from that the malad the
How can you get the information by this weekend? Monday we can have it?
Monday malad it will be difficult malad.
Tuesday, you get 1 week?
Malad.
Just it's a telephonic instruction. What is the status? Nothing else. Tuesday, madam, you're there?
yes, Lordship.
Third, Miss Anne Duncan, learned counsel for the appellant, full stop. Also heard Sri M. Kato, learned deputy SGI, who however submits that there is a subsequent selection process. Full stop. He submits that the present status of the subsequent of the same is not known to him, and therefore he prays for some time
Well.
to get the present status.
The records also, Lordship.
As agreed to by the learned counsel for the parties, list on 30. Next is 3031. First of 3, Kato would also produce the records of the case which pertains to the decision for cancellation of the selection process, which is the subject matter of this list.
Malad may I afraid it malad can it be on 7th malad? It's because there are some documents may be malad in at Shillong malad. Interview was basically
Shillong is
conducted at
not so
Shillong.
far, Lordship. It can
Shillong
be.
is where? US.
Malad,
Yes, ask somebody to send it. We are giving you a week's time.
malad,
We are giving you a week's time.
malad.
You have got air services also nowadays.
Malad, here the difficulty is malad we this manpower are malad recruited for
You try, we'll see.
malad.
Obliged.
Can it be converted into appeal as per the order provided?
We have passed the orders. You have already wasted much of our time. Not now. And revision cannot be converted into an appeal. Appeal can be converted into a revision.
That is provision is there, Lordship, provision 1, provision 5, Lordship. I was paying for them.
We will not.
Obliged.
And the compensation have been dispersed till now.
What is the is there any urgency in a contempt matter? It can come normally. We don't have a problem taking up the matter, but not by mentioning. It will not be listed tomorrow.
No, it won't.
Have you filed or not?
Yes,
No, at least you take a look here. No.
it's,
We'll get it. Okay.
Your Lordship, I beg to mention item number 18.
1-8.
Mm.
Yes,
Your Lordship, the parties have been amicably settled the matter outside the court. So Your Lordship, I humbly pray I may be allowed it to withdraw this instant matter.
item 18. Who's for the other side? Madam, you are there.
Yes.
What is your name?
Amy Aram?
You're on behalf of Mr. T. Sunil.
Yes, Your Lordship.
नाम लिख लीजिए हाँ? Miss M. Aram, Learned Counsel, appearing on instruction of Sri T. Sunil for the petitioner, submits that during the pendency of this writ petition, the matter has been amicably settled. Full stop. Also heard, Mr. Kamduk, you are there? Land Management? Also heard, Ms. Yorongo,
Yes, ma'am.
Learned State Council, as well as Sri D. Kamduk, Learned Standing Council Land Management Department. Full stop, para. Writ petition. Yes, we have recorded your name, Mr. Kamduk. Writ petition is accordingly dismissed on withdrawal. 18 has been amicably settled. Withdraw. Okay. Please give your name to your, no. Okay, don't worry.
Lordship, I beg to mention item number 10 and 17.
10 and 17.
Yes. It may be listed day after tomorrow.
You want this matter day after tomorrow?
Yes, the day after tomorrow.
Mr. Sonar, you are there? 10.
My lord, I am dealing with. It's an urgency in the matter, my lord. What happened, my lord, that last order, 3 weeks was only granted to the state to file that affidavit in opposition. Urgency is this is a tender matter. And my lord, only the.
No, he's praying for a
So, Lordship,
short accommodation. When do you want?
yes, Prime Minister.
Tomorrow. Then.
Tomorrow?
Okay, then, yes, sir. Lordship.
Tomorrow.
My lord,
Yes,
along
tomorrow.
with my lord, similar matter is there, this writ petition 545, I think, my lord. It has to be.
Is it listed today?
Not listed today.
What you are praying on behalf of the respondents?
No, but I'm to the
No,
petition.
no.
Yes, I'm on the beg of respondent, sir.
Which respondent?
Respondent number 1 to 5.
Oh, you are for the state respondent.
Yes. Give me Tarak. For the council for the department,
Which department?
RWD. RWD.
RWD.
Yes, noted.
A prayer for accommodation has been made on behalf of the department. Full stop, para. Sri R. Sonar, Learned Counsel for the petitioner. However, expresses urgency in this matter as it is relating to a contract. Full stop, para. Para. He further submits that there is another analogous matter, WPC 55
545.
545
Yes.
of 23.
Yes, ma'am. This is 546, no?
This is 546.
546, yes.
546.
List this case tomorrow along with WPC 545 of 2023.
Much.
And also, Lordship, item number 17.
17. Yes,
Yes.
17. What is your prayer?
Uh,
Similar prayer.
no,
Madam?
yeah.
So Lordship, may be taken up day after tomorrow.
Day
Tomorrow I'm bit.
after tomorrow will be difficult on our part. Difficult day after tomorrow. There may not be a single bench.
Then on Monday, Lordship, because tomorrow I'm bit preoccupied.
Monday.
Obliged.
On a prayer made on behalf of the department, matter is adjourned to be listed on. Is it 29th? 29/1.
Interim order is Lordship.
Sarah, interim order passed earlier, stands extended till the next date of listing.
obliged.
May it please, my lord.
Yes,
My lord, through this writ petition, the petitioner is challenging that termination order dated 23/11/2023, my lord,
termination from what?
by which, my lord, the petitioner from the post of MTS has been terminated.
From the post of
MTS,
MTS,
Yes, madam.
multitask.
yes. The brief fact is there, my lord. The petitioner was appointed on compassionate ground upon the demise of her husband, late Tasor Tasing, my lord, who died while in service, serving as TGT, posted at Village Suble, Siang district, my lord.
Was this termination preceded by any inquiry?
Yes, my lord. After the demise, my lord,
No, was there any inquiry before your termination?
except a so-called notice, my lord.
So cause notice was given
Yes,
to
my lord.
you.
So-called notice was served, my lord, and accordingly it was replied.
Thereafter,
However, my lord, the
Yes,
say was not
Mr.
considered.
Thakur.
My lord, this my lord, her appointment, my lord, at page 26, my lord. This was done by the then director, my lord. Actually, he has issued so many that illegal and in fact, without approval of authority, it is in the order, it is shown to have been approved by the government, but nothing and such has been done. And this large scale of the illegal appointment has been
Okay,
done by
we'll
him.
issue notice at this.
My lord.
Heard,
May I submit, my lord?
yes,
My lord, I am praying for interim, my lord, pending disposal of the case, my lord.
My
Because, my lord, the petitioner is a widow, my lord, since after the demise of her husband.
termination cannot be stayed.
My lord, because
Termination,
she
will
was
have
purely
the
appointed
response-
on compassionate ground, my lord.
Staying of a termination will amount to giving you the final relief on the first day. When was the order passed?
The termination order was passed on 23 November 2023. my lord.
Actually, no, otherwise also it's quite late.
And my lord, as I see also.
Why did you issue notice? Your name?
David Tatak, my lord.
You are not there on record.
It is there, my lord. The registry has not reflected the name in the cost list, my lord.
Okay. Why? Registry does not like you.
I am, my lord. When I have submitted,
Maybe you also do not like the registry, therefore.
it's in the
Reciprocation.
Wakalat Nama, my lord, but not reflected in the cost list.
Okay. Heard. So and so. D. Tatak, learned counsel.
D. Tatak, my lord.
Yes, D. Tatak. David Tatak.
Yes, sir.
Any doubts? No doubts. Registry may not like you, courts likes you. D. Tatak, learned counsel for the petitioner who has put to challenge an order dated 23/11/2023, by which the services of the petitioner has been terminated, full stop. It is the case of the petitioner that she was appointed as a multitasking staff within bracket MTS on compassionate ground, and the impugned termination has not been done by following the due process of law. Full stop. Para. Sri T. Tagum, the learned standing counsel, Education Department, has however submitted that the initial appointment of the petitioner was done without following the due process, and therefore steps have been taken. Full stop. Para. Let notice be issued, returnable by 4 weeks. Civil Secretary, yes.
Yes.
Ram, yes. Resource to learned state council accepts notice on behalf of Resolution 1. The rest, I think.
Yes,
you-
my lord, yes.
T. Tagum Learned Standing Council, Education accepts notice on behalf of the rest of the respondent numbers 2,
2 to 7. my lord.
TO2, 7, 2 to 7. Para, let extra copies of the petition be served upon the Learned Council for the respondents by tomorrow.
Much obliged, my lord.
For Mr. Tara, my lord, here my lord pleadings are completed. This can be posted for hearing, my lord. May I, Lordship? Lordship, matter may be passed over for tomorrow, my lord.
That's what I'm saying.
He's asking for tomorrow. Why?
Tomorrow, my lord.
Why tomorrow?
Why tomorrow?
Oh, my lord, I forget to bring the report, my lord.
But you have not forgotten to come to the court. Have you come to the court? You have. You have everything in your mind. You have studied this brief. You know it by heart. Why do you need the brief? What is the matter about?
This is tender matter, my lord.
Tender matter. That much you know. Okay. Yes. When? Tomorrow?
Tomorrow, my lord, as I've said, mother, please complete that. And private respondent, they are not coming forward. So this matter is posted for hearing, mother. Any date next week, my lord, no issue.
Non-necessary. Despite the service of notice service. Await the service. Now, how is the
They have filed an affidavit, my lord.
One counsel has appeared for 4, 5, and 6. Who is appearing for 4, 5, and
I'm
6?
not aware of that. Who is that? Any idea?
No idea, sir.
There is a Noni Nobe. Is there somebody called Noni Nobe?
No.
Just check the file records.
Only now.
Noni Novem. Sir, my lord, I am Noni Novem, sir, my lord.
Oh, you have received the dusty service.
Yes, my lord.
Okay. Have you taken the dusty steps?
Yes, my lord.
Where is your affidavit? Suddenly you remembered your name. Where is the dusty service? Affidavit. Where is the affidavit? Have you filed affidavit regarding dusty?
Oh.
Yes, you have filed. You have not.
Other also, my lord, based on the.
Lordship, pardon me, actually, by mistake, I have taken,
Another thing.
Lordship, I have taken step upon respondent 4, 5, and 6, Lordship.
Okay, have it tomorrow then. Let Mr. Tara come. He may not be. he's not-
Tomorrow, then
No,
maybe
no,
day after
no.
tomorrow, my lord.
Day after tomorrow not be possible.
Oh,
Next Monday?
Next Monday, my lord.
Next
Lordship, by mistakenly, I have said tomorrow, actually, that is for different matter, my lord. That's why I'm saying for tomorrow, my lord.
What did you have for dinner last night? Or this morning? Breakfast, it seems.
Actually,
Okay.
Monday, my
Monday.
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 A prayer for adjournment has been made on behalf of the
Monday. Come.
petitioner. Full stop. Also heard Sri R.H. Nabam, the learned additional AG. Full stop para. As agreed. List on
29, my lord.
29.
Oblige.
Yes. No, we go ahead. Report. Yes, Mr. Perme is also there. What is this?
I'm representing respondent number 3 and 4, my lord. On my part, my lord, I have initial epidemic, my lord.
Yes, Mr. Council, what do you say?
Lordship, government will not file affidavit.
Government has not filed affidavit, madam.
We have not received the instruction, so some more time may be needed, your lordship.
22 matter, you get the instructions first. It's already late. Come look for
Well, for respondent number 2, no, sir.
file affidavit.
No, sir. Here, I will not be filing a paper.
And permit for
3 and 4.
private respondents,
No, my lord. State respondent, my lord. Department agriculture.
Department of
Agriculture.
Agriculture. And Madam for,
Respondent number 5, Your Lordship,
who's five?
ADC, Your Lordship, Additional Deputy
ADC's
Commissioner.
affidavit will be required or what? What is the issue about?
This is regarding land allotment to the private respondent. Lord.
Your stand will be required, I think.
Yes, yes.
Do the Department of Agriculture represented by Sri L. Permit, Learned Counsel has filed the affidavit in opposition, comma. The respondent number 5, ADC, represented by Ms. P. Pangu, Learned State Counsel, has not filed the affidavit in opposition. Full stop. Sri Kamduk, Learned Standing Council, Land Management Department submits that affidavit may not be required to be filed by his clients. Respondent numbers
Two, Lords.
2, full
Yes.
stop para. On the request of Ms. Pangu, the Learned State Council, comma, list after 3 weeks to enable her to file the affidavit in opposition. Is there any interim order? No interim order.
Wait, Lords.
Yes.
My lord, your counter has been received, but I pray for 2 weeks' time to file a rejoin.
You have filed the counter affidavit?
Yes.
Ms. Wangmo, Learned State Council submits that affidavit in opposition has been filed, full stop, para, on the prayer of Sri D. Pangi, Learned Counsel for the petitioner, comma, list after 3 weeks to enable filing of rejoinder affidavit.
There is a my lord interim.
Para, interim order passed earlier, stands extended till the next day of listing.
Hold.
My lord, in terms of the order dated 11/1/24,
Hmm.
they have come and has filed an affidavit saying that vigilance clearance has already been given. My prayer was for issuance of vigilance clearance.
So you can, I think we can close this.
Yes.
Heard Ms. N. Rangan, Learned Counsel for the petitioner. Whereas the state respondents are represented by Ms. R. Basar,
Your Lordship.
Learned State Counsel. Full stop, para. The issue was with regards to the pension of the petitioner, which was withheld for non-grant of the clearance by the Vigilance Department, full stop. Ms. Duncan, the Learned Counsel for the petitioner, however, submits that in the meantime, comma, such clearance has been granted and the said fact has been brought on record in the affidavit in opposition
Yes, Your Lord.
filed by the state respondents, full stop, para. In view of the aforesaid development, comma, this court is of the view there is no live cause of action to be adjudicated, and accordingly, the writ petition is closed.
Obliged.
May I please, your lordship?
Yes.
Lordship, in this instant writ petition, I have prayed for setting aside and quashing of impugned transfer posting order dated 31/7/2023, which is at page 17, lordship. So through this.
Are you ready with the matter? Yes. You can take it up for disposal, yes.
Yes, lordship. Through this impugned transfer posting order 31/7/2023, the petitioner was transferred and
Just a
posted.
minute. Where is the order?
Page number 17, lordship.
17.
Yes, lordship.
What is your names?
Yamang
Yamang. Tali.
Tali, yes, lordship. It's a casual staff. So as per this order, as per this transfer posting order,
Transferred from
from Boleng division to Yingkiong division, Lordship.
as casual staff.
Yes, casual staff, along with the post, Lordship. By the
Transfer from
superintending.
Boleng is in the, it is in the same district.
It's Boleng is Siang district and Yingkiong is Upper Siang district.
From Boleng division to Inkyong division. Yes.
And thereafter, after this impugn transfer posting order, may I take Lordship to page 24, Lordship?
24.
Yes, Lordship.
Yes.
This is the impugn reposting order by the executive engineer, Lordship. She was again transferred and posted from Boleng to Tuting division, Lordship.
This was not given effect to the first order 31/7.
Lordship.
31/7/23 was not given effect to.
Lordship.
It was modified.
No, it was not modified, Lordship. Since this after the issuance of this order, I have made a representation before the competent authority. But on the fear of losing my job, I have joined there at Yingkiong. And
You had joined.
Yes, within a span of 3 days, I was again reposted to Tuting, which is around 100.
When did you join Inkyong?
Yingkiong, Lordship,
Okay, it doesn't matter. Reposted. Okay, reposted at Tuting.
Tuting, yes, Lordship.
This is of which date? 16/8.
16/8, Lordship. 31/7, 31/7, I was posted from Boleng to Yingkiong. Then from Yingkiong, I was again reposted to Tuting by the executive engineer, Lordship. Lordship, basically, Lordship, my contention is that this particular transfer posting was effected at the behest of the Honorable Local MLA, Lordship. The issue here is prior to this issuance of this transfer posting order, Lordship.
Yes.
The husband of the petitioner has filed a writ petition before this Honorable Court against certain hydropower project, which was being carried out without taking the consent of the local villagers, Lordship. Against that, a writ petition was filed, and the husband of the petitioner was one of the petitioners. In that instant, in that writ petition, Lordship, that I have enclosed in page 25, Lordship, Annexure 7, Lordship.
Okay.
So, husband of the petitioner is petitioner number 1 in writ petition number 384/2023. Sri Tajom Tagu is the husband of the petitioner, Lordship. Now, accordingly, this Honorable Court was pleased to stay the execution of the project of that small hydel power project, which was being constructed at a place called Mabung, which is under Siang district, Lordship. So, husband of the petitioner.
But this order has been, yesterday it has been vacated.
Lordship. Just I am taking reference to. So, the reason for, Lordship, the reason for.
Okay, doesn't matter.
And thereafter, since the husband of the petitioner was involved in this instant writ petition, so the transfer posting was given effect to. That is my basic allegation, Lordship. And moreover, she has been, the petitioner has been working in that Boleng. So that, and she has been regularized just recently. And thereafter, on the basis of this writ petition, she was transferred and posted there. Now, as per the reply, Lordship, and accordingly.
Where are you now?
I am, accordingly, Lordship, this Honorable Court was pleased to.
No, we have seen, there's a stay order. Where
Yes,
are you now?
I am still at Boleng, Lordship.
But you had joined Inkyong.
No, Lordship, on the basis of that previous interim order, Lordship, the first transfer posting order as well as subsequent transfer posting order was stayed, Lordship. So on the basis of that stay order, I have
The
rejoined.
first order of transfer of 31/7/2023,
Yes,
that
sir.
is not the subject matter of challenge.
That is the subject matter of challenge.
No, you had said that you are challenging 16/8/2023.
No, both, Lordship.
Both.
Yes, Lordship. I'm challenging both, Lordship. That I have since I have informed this court that I have joined that place on the fear of losing the job. But considering the allegation in this instant writ petition, the Honorable Court was pleased to stay both the impugned transfer posting order, Lordship. Now, Lordship, I have been working there at Boleng, Lordship. After the order, interim order passed by this Honorable Court, interim order dated 29/8/2020.
Just a minute. Your ground is only that since your husband was one of the petitioner, so the local MLA had a grudge against him, so you have been transferred.
Yes, Lordship.
That is the only ground.
Yes, Lordship. And
Otherwise, how long have you been serving at Boleng?
Boleng, Lordship, I have been there for the past 7 to 8 years, Lordship.
7 to 8 years.
Yes, Lordship. And Lordship, that another ground is the petitioner is not required at all there, because had it been the case that she was required at Yingkiong, she would not have been reposted to Tuting as a punishment posting, that too within a span of 3 days, Lordship. That is my another ground, Lord. And considering her position, Lordship, she is just a casual staff, Lord.
Yes. Mr. Rapin.
Lordship is aware, Lordship. So for transfer and posting is concerned, the Honorable Court has a limited Lordship independence. If Lordship see the present with petition, Lordship. Here, Lordship, so for the violations of any guidelines or any law is not, Lordship, that's not the issue here, Lordship. Even the petitioner said she has spent more than 8 years in the present posting place, Lordship.
Yes.
Whether, Lordship, the superintending engineer is competent or not, Lordship. Just, I would like to take Lordship to my affidavit, Lordship. My affidavit, this is the affidavit filed by respondent number 225, Lordship.
Yes.
Kindly come to page 11, annexure 1. Lordship, this is the Lordship guidelines and regulating scheme of all these casual staff and all, Lordship. Here, Lordship, the appointment, promotion, and service of work charge staff and casual workers under this is being governed by this very particular, Lordship, scheme.
OM.
Yes, Lordship. And I'm taking, Lordship, to page 18, the relevant.
Page?
Page 18, Lordship.
Yes, good.
Page 18, close 12, Lordship. Down below, bottom. Transfer and posting, Lordship.
Yes.
Interdivision transfer within same circle, Lordship. This is the transfer, Lordship, within the same circle. This Boleng and the Yingkyong, Lordship, it comes under one circle, Lordship. And therefore, as per this very provision, Lordship, transfer of work charge, staff and casual workers from one division to another within the circle shall be made by the superintending engineer, Lordship, who is a competent, Lordship. And these two division comes under the same circle.
What is the name of the circle?
Circle name. This is a Boleng civil circle, Lordship. Boleng civil circle, Lordship.
No, Mr. Topin, perhaps you can address straight on the point which he has urged. He has not urged any violation of statutory rules. On our pointed query, he has also said that he is at Boleng for around 7 to 8 years. He is only making a ground that since the husband of the petitioner was on the
I'm coming.
address on that.
I'm coming to the Lordship.
Rest will take care.
Lordship, when Lordship, the malapadi and this sort of allegations raised, Lordship, there must be some sort of express, Lordship, materials in satisfaction of this honorable court, Lordship, from where we can independence, without any, Lordship, unequivocally we can gather independence that this is the reason behind the, Lordship, the action. But here, Lordship, will find that material is not here, Lordship. In that writ petition also, Lordship, the ML is not the party there, Lordship. Simply, Lordship, that writ petition is there, and because of that, this transfer has been initiated. Something must be there, Lordship. Otherwise, Lordship, this excuse and this ground will be very available for each and every, Lordship, person, Lordship. So, what I'm submitting, there must be something, Lordship, in satisfaction of this.
Here, the MLA has been made a party, Response 6.
Yes, Lordship. Here, Lordship, made, Lordship, the earlier writ petition, Lordship. In that writ petition.
No, earlier writ petition, there was no requirement to have the MLA as a party. The malafide is alleged in this petition.
Well, ground is that writ petition.
Yes, ground is that petition. And because of that writ petition, this MLA got irritated, so he has transferred, and therefore, in this decision-making process, he has played a role. That is the version of the petitioner. He has made.
Yes. No, what I'm pointing out, Lordship, that in that writ petition, the MLA was not the party. What I'm submitting is, Lordship, this sort of ground, if it's permitted, Lordship, it will be available for each and every, Lordship, employee, Lordship. Because, Lordship,
Mr. Tapin, we are here to examine the grounds. If we find that the grounds are frivolous, we will not consider. But he is trying to link a case which her husband had filed, which has urged the MLA, and MLA took a decision to transfer her from one place. And he has also made an additional ground which will seek your response, that her service at Inkyong was not at all necessary, because in 3 days she was again transferred to some other place.
No, I'm coming to that, Lordship. So, for the role of the MLA is concerned, Lordship, what I'm submitting, there must be some express action, Lordship, in satisfaction of this honorable court. There's nothing on the record, Lordship, to say that, Lordship, it has been initiated under the directions of the MLA, Lordship. There's nothing on the record, Lordship. This is a mere allegation, Lordship. Sweeping statement, Lordship, I think Lordship is aware, Lordship. Mere sweeping statement is not, Lordship. That's
where is the
where
are the pleadings with regard to the role of the MLA?
Lordship,
where are the pleadings with regard to the allegation connecting the role of the MLA?
Lordship,
is it paragraph 12?
Paragraph
9 also.
Paragraph 9, Lordship.
No, 9 is only, filed.
In paragraph 9 of this,
Interested party, reform. No, 9, he says that MLA is there, interested party, then come to 12. 12, I think, is the only averment at page 9. Please read
Lordship, paragraph
12.
12. Also, is always the prerogative of the government, and the employee is always obligatory to the transfer and posting policy of the government. If the same is done in public interest, but public interest includes the interest of the employee and his or her family members also. In an instance case, the petitioner has been intentionally made to be harassed and suffer in order to meet up the personal vendetta of local MLAs. This is a statement, Lordship.
You have got the records,
Records is
file.
records is not.
Get the file. If there was no interim order, then probably we'd have taken a different view. There's an interim order.
No, sir.
She is still there. We cannot be oblivious of the fact that she has completed around 7 to 8 years.
No, sir.
One person cannot stick in a place.
No, sir.
That you are right, but we are just want to see whether this is a transfer simpliciter or is it at the behest of somebody? We want to see the records.
But here, Lordship, also for authority, who is the transferring authority. Here, Lordship, in reply to that, we have clearly made, because manpower is required, dear Lordship, we have made our.
Then why did you transfer again to?
No, I'm coming
how-
because
what is that?
here, Lordship, so far, Lordship, this second transfer is concerned.
Correct.
I am coming to that. Kindly come to Lordship this. Page 24 of the read. Sorry. Page 24, Lordship. Read petition. Page 24.
Of the repetition?
Yes, Lordship. Read petition.
Yes, please.
In pursuance of the orders number so and so, that is so and so, of the superintending engineer, bowling circle, so and so, bowling. Srimati so and so, casual staff who has joined in this division on 9/8/2023 is hereby reposted under assistant engineer tuting subdivision. Feasible for further duties. This is not exactly transfer losses. In one division losses, there are so many subdivision losses. One has to be losses posted there losses. This is not the losses transfer. Suppose someone has joined before this high court and he has to be given this post and that charge losses. This is only losses arrangement, internal arrangement within the division only losses. And that is not disputed loss. It's not that law he has been transferred to another loss division again. This is only the internal arrangement within the division. Because he has to given the charge lawship. And where the lawship post is available, lawship, vacancy is available, she will be given there only lawship. Accordingly, she has been. After within 3 days, she has been given the charge. This is the only posting order loss.
Do you mean to say that Tuting subdivision is a subdivision under Inkyong division?
No, it is a subdivision, Tuting division.
That is, so Tuting is a subdivision.
Tuting is a subdivision.
Is it under the Yungkyong division?
This lawship, this assistant engineer Tuting subdivision, it comes under the lawship
Inkyong
Inkyong division.
Okay.
Inkyong division.
So from the first order, from Boleng to Inkyong division,
Inkyong
one
division.
division to the other.
Yes, 2 division.
And in Inkyong division, there are several subdivisions, including Tuting. And she was therefore given a posting in the subdivision Tuting, which is under Inkyong. It is not a transfer.
No, it's not a transfer.
It is within the division of Inkyong.
He lost. Firstly, from Bowling division to Yingyong division. And within the Yingyong division,
it is only a matter of posting. Where
yes,
should it be posted?
Lordship, the
Oh, we'll come back to that.
even she has joined lawship because the interim order lawship has been passed. Otherwise, there is only one transfer order, which she has already complied also. And second is the only the arrangement process.
Okay.
So therefore, I lordship from my side, I don't find any lordship material where lordship. And so for MLA is concerned, they are also in the read petition. It's not that lordship he has done this, he has initiated so and so. That is not.
Yes, yes, Mr. Tata.
Lordship, so far as the reposting is concerned, Lordship, as since I have SL this on the ground that this reposting was done within a period of 3 days. Of course, Lordship, it is within the same division, Lordship. But my contention is, Lordship, her posting to from Boleng to Yingkiong division is absolutely not required, Lordship. Since if she was required there, she would have remained there. And from there, it was she was again transferred to.
No, your this submission of yours, though at the first class appears to be impressive, but we find that Tuting is one of the subdivisions under Inkyong. The
Yes, Lord.
first transfer
Yes.
is from one division to the other division.
Another division, yes.
The transfer order could not have been envisaged that you were in which subdivision you are to be put under Inkyong division.
Yes, Lord.
It is the duty of the executive engineer of Inkyong division
Lordship.
to see where are you required to be posted.
Yes, Lordship.
After you have joined the division
Lordship.
of Inkyong, he takes a call that you be posted in the subdivision Tuting.
Lordship.
That may not be a transfer per se.
Yes, Lordship.
It's only a question of posting you within the Inkyong division itself.
Notice that Lordship, that is exactly what I'm saying. That the transfer posting initially from Boleng to Yingkiong to different division. Now
Yes.
we although Tuting and Yingkiong comes under same division, Tuting is one of the subdivision.
Yes,
Lordship may kindly consider the geographical proximity, Lordship.
yes.
It is from Yingkiong, it's more than 100 plus 150 kilometers, and Lordship is aware of the terrain, hilly terrain of the area. Now she was posted during the
Now tell us one thing. The learned state council has said that both Boleng's division and the Inkyong division comes under the Boleng circle.
Lordship.
Not disputed.
Lordship.
The initial order was passed by the superintending engineer, who is the competent authority.
Yes, the competent authority.
He transfers you from one division of Boleng to another division of Boleng. He could not have envisaged under which subdivision of Boleng circle geographical proximity, of course, that we will not ignore. We'll also take that into consideration. But and how have you connected the MLA's role? Only for some averments here directly you have not been able to connect.
Lordship, so far as the writ petitioner is concerned, Lordship, although it is not, we could not get hold of certain records or documents to demonstrate that these particular documents, I mean, through these documents, this transfer posting has been effected. However, Lordship, the fact remains that, Lordship, since there is an allegation against them, we have taken a step upon respondent number 6 also. So that has been uncontroverted, Lordship. So that part also can be considered, Lordship. And Lordship, with regards to this reposting, of course, Lordship had rightly pointed out that it is the prerogative of the
Executive engineer, how to utilize your service, where to utilize your service.
Lordship. But Lordship, since casual staffs, they are.
If you make out a case that casual staff cannot be transferred at all, that matters will be different. But you cannot make out a case because there is an office memorandum which is on the field of how do you treat the service conditions of casual staff. London State Council has taken the code to the OM of 13/8/2007.
Lordship.
Under those conditions, it may be difficult for us. Transfer orders, as you know, unless those are violation of the statute, or you can establish a case of malafide, exercise of powers.
Yes, Lord.
And what is against you is the long period which you have served at Bowling, 7 to 8 years. I think that's a low good.
I was working there as just a contingency. Only recently I have been regularized, Lordship. This is another aspect.
Doesn't matter. Okay, heard. Three, A, Tatak Learned Counsel for the petitioner. Also heard. Three, S. Tapin, Learned Senior Advocate, Arunachal Pradesh. Full stop. Para. Have a seat. The petitioner has the petitioner, who is a casual staff under the PWD, has put to challenge 2 orders of transfer. Full stop. The first order is dated 31/7/2023, whereby she has been transferred from Bowling Division to Inkyong Division, and by the subsequent order dated 16/8/2023, she has again been reposted in the Tooting subdivision. Full stop. Para. The learned counsel for the petitioner has submitted that apart from the fact that frequent transfers are not permissible in law, the impugned action is on the behest of the local MLA, who has also been made a party respondent in the present case. Full stop. He submits that the entire action is triggered after filing of a writ petition by a group of petitioners, which included the husband of the petitioner, in connection with a hydel power project. Full stop. In the said writ petition WPC 284/2023, there was also a stay order, and the contention of the petitioners in that case was that the local villagers were not consulted, and the project would adversely affect their life. Full stop. It is further submitted that this court had also passed an interim order in that case. Full stop. It is the case projected that since the local MLA was interested in the project, took a grudge against the petitioners in that case, and since the husband of the present petitioner was one of the party, the petitioner is now having required to face the brunt. Full stop. Para. It is submitted that there is no public interest attached with the impugned transfer, inasmuch as, within a very short time of 3 to 4 days of joining the Inkyong division, Inkyong Division pursuant to the first order of transfer dated 31/7/2023, the petitioner was again reposted to Tooting subdivision, wide order dated 16/8/2023, full stop. It is also submitted that apprehending some penal action, the petitioner had joined the Inkyong Division, whereafter the second impugned order was passed. Full stop. 3. Tatak, the learned counsel, has however informed that wide order dated 29/8/2023, this court, while issuing notice, had stayed both the impugned orders of transfer, pursuant to which, the petitioner is continuing her service as casual staff at the Bowling Division. Full stop. Para. The learned counsel has, however, fairly conceded that the petitioner has completed more than 7 years at Bowling, but that factor was not the consideration for her transfer, which has been done, according to the petitioner, with malafide intention. Full stop. Para. Per contra, 3S Tapin, learned senior government advocate, by referring to the affidavit in opposition filed on 13/10/2023, has submitted that there is no allegations at all of any violation of any rules governing the service condition in connection with the impugned orders of transfer. Full stop. It is submitted that the petitioner has completed about 8 years at Bowling subdivision, and therefore it is in the interest of public that the order of transfer has been passed, which is also in accordance with the OM dated 13/8/2007. Full stop. The State Council has specifically referred to clause 12 of the said OM, which relates to transfer and posting. Full stop. Para. With regard to the submission of frequent transfer, the learned State Council has clarified that Bowling Division and New Inkyong Division of the PWD falls under the Bowling Circle, and the first and the order of transfer dated 31/7/2023 was issued by the competent authority, namely the superintending engineer of the circle. Full stop. Tapin clarifies that the subsequent order dated 16/8/2023 is not an order of transfer, but only an order of posting of the petitioner in Tooting, which is a subdivision under the Inkyong Division, and that order has been passed by the competent authority, namely the executive engineer of the Inkyong Division. Full stop. Para. Countering the allegation of malafide by which the petitioner has tried to rope in the role of the local MLA, comma, the State Council submits that in the WPC 284 of 2023, which has been stated to be the root cause, comma, the MLA, local MLA, the concerned MLA was not made a party. Full stop. It is further submitted that the allegations of involvement of the MLA, which has been put in paragraph 12 and 13 of the writ petition, are absolutely vague. Full stop. He submits that allegations of malafide is to be demonstrated by materials from which such allegations becomes apparent, and simply making an allegation would simply relying upon some stray allegations would open a floodgate of litigations wherein on such basis, comma, any order of the administration can be put to challenge. Full stop. The State Council finally submits that there is no malafide involved in the instant action, in the instant process of transfer of the petitioner, who has otherwise completed about 8 years at the Bowling Division. Full stop. Para. The rival submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. The law regarding transfer is well settled. Full stop. Unless an order of transfer is in violation of the statutory rules, or the same has been done in malafide exercise of powers, comma, such orders of transfers, which are mainly done for the exigency of service, are not liable to be interfered with by a court. Full stop. It is also tried law that prerogative and discretion should be granted, should be left with the administration as to how the services of its employees are to be best utilized within the framework of law. Full scope. Of course, comma, the same would not mean that such discretion is to be exercised, can be exercised without any application of mind or with an intention to penalize. Full stop. Para. In the instant case, comma, the fact that the petitioner has been serving at Bowling Division for the last 8 years is not disputed, and therefore it is in fact right for transferring the petitioner, which would meet the interest of justice. Full stop. The contention raised about frequent transfer cannot be countenanced in view of the fact that Tooting is a subdivision under Inkyung division, and therefore reposting of the petitioner after her joining, reposting of the petitioner at Tooting subdivision after her joining at Inkyung division cannot be held to be a separate transfer, but has to be construed to be a part and parcel of the principal order of transfer dated 31/7/2023. Full stop. The competency of the officers passing the orders dated 31/7/2023 and 16/8/2023 are not the subject matter of challenge. And in fact, this court has noticed that those orders are passed by the competent authority. Full stop. Para. This brings this court to examine the aspect of allegation of malafide vis-a-vis the role of the MLA, who has also been impleaded as respondent number 6 in this petition. Full stop. The allegation is that the husband of the petitioner was one of the petitioners in a writ petition which was filed against a hydel power project, and there was a stay order in the said writ petition. Full stop. The averments made again in this regard are found mainly in paragraphs 12 and 13 of the writ petition. Full stop. On a reading of the said averments, this court cannot come to a conclusion that the allegations of malafide has got any substantial basis with the order of transfer. Full stop. And as rightly contended by the learned state council, though an allegation of malafide may not be able to be proved beyond all reasonable doubts, there has to be substantial materials so as to enable the court to come to a conclusion that there is a perceived notion of malafide which can be demonstrated by the materials on record. Full stop. The pleadings with regard to the allegations made in this writ petition do not meet the said standard, and therefore it is difficult on the part of this court to accept the allegation of malafide in connection with the impugned order of transfer. Full stop. In view of the above discussion, and also taking into consideration that transfer being an exigency of service, and the petitioner has already served about 8 years at the Bowling division, the impugned orders of transfer are not interfered with. Full stop. Accordingly, the writ petition is dismissed. Full stop. The interim order passed on 29/8/2023 is vacated.
Deeply obliged.
My lord,
Yes,
My lord, here I require, I have not yet received the Paravel's comment, my lord.
who's for the petition? Item number?
Item number 5, my lord.
Mr. T. Soon. Where is Mrs. Soon? He was here yesterday. None appears for the, anyone of his colleague? Who is connected with him, at least pray for an adjournment. None appears for the petitioner on call. Petitioners on call. Full stop. Para. Three T. Tagum, Learned Standing Council Education.
Madam.
However, submits that instructions are yet to be received. Full stop. He accordingly prays for
4 weeks.
and is granted 4 weeks time to obtain instructions / file affidavit in opposition. Madam, you are also filing. Ms. Wang Mo, Learned State Council is also present.
My lord, this matter can be closed since the petitioner herein has approached honorable division bench against the interim order. So while deciding that writ appeal, division bench has closed that writ appeal as well as this instant writ petition. So
Is it, madam?
Yes, Your Honor, I have a
Yeah,
copy of both.
What is your name? Your name?
Yeah, Tapiomo.
You're not there on record.
Yes, my lord, I'm
Okay,
there.
okay. Heard Sri T. Omo, Learned Counsel for the petitioner. Also heard Ms. R. Basar, Learned State Counsel, full stop para. Sri Omo, the Learned Counsel for the petitioners. Yes, has however submitted that against the order dated 11/10/2023 passed by this court, the petitioners had preferred a writ appeal being WA 404 of 2023, which however has been closed with a further observation that the writ petition would also accordingly with further observation that the writ petition was also accordingly closed. Full stop para. The Learned Counsel has also placed on record a copy of the order dated 19/10/2023 passed by the Honorable Division Bench in WA 404 of 2023. Full stop para. Ms. Basar, the Learned State Council, endorses the aforesaid submission. Full stop para. In view of the aforesaid development, no separate orders are required to be passed in this petition, and the same stands closed in terms of the order passed by the Honorable Division Bench.
Most obliged.
My lord,
Yes,
at number 7, my lord, the petitioner has not yet served the requisite extra copy.
I will serve it today, man.
okay. What is your name?
M. Doji, man.
Sri M. Dozy, Learned Counsel for the petitioner, undertakes to serve extra copies of the writ petition to Sri T. Tagum, Learned Standing Council Education, as well as Sri Sriram, the
We have
Learned-
received the copies.
T. Tagum, Learned Standing Council Education, full stop para. List after 4 weeks
Four.
for instructions.
Deeply observed.
Is there any interim order?
My lord, there's no entry.
No interest.
Yes.
I pray more time, my lord.
Extra
I'm
copy
yet-
served.
Yes, my lord. I'm yet to receive instruction, my lord.
Madam,
I need time to file affidavit.
I heard
M.
Sri
Dozy.
M. Dozy, learned counsel for the petitioners. Oh no, इसमें petitioner हो, पहला में petitioner था, इसमें एक देख लीजिए, you see the cause list, is the petitioner, full stop para. Both Miss R. Basar, London State Council, as well as Sri L. Permit, London Standing Council Agriculture, brief for and are granted 4 weeks time to obtain instructions, less file if in opposition. All right.
Obliged.
No interim order?
No interim.
Yes.
My lord, this
madam?
is regarding on
Yeah,
cancellation
go.
of, yes, my lord. This is
Wait,
regarding
wait.
cancellation of arm license, my lord. Yeah, my lord.
Cancellation of
Arm license, my lord.
arm license.
Of the
You
petitioner.
filed your affidavit.
No, my lord, I've received the instruction, my lord. I will be
None
filing.
appears for the petitioner on call. Full stop. Ms. Wong, the learned state council, however, submits that instructions have been received and she would like to file an affidavit in opposition. Full stop. Para, list after 4 weeks to enable filing of such affidavit in opposition.
Yes, sir.
Yes.
Yes, Lordship. Lordship, here the petitioner is retiring on 31st of 2024. So no objection certificate is not been issued to him for a pension just because petitioner wife has applied for a land allotment. And your instruction was seek from the government.
Yes, my lord,
He's retiring on this 31st.
yes, my lord.
Yes, Lordship.
Okay, yes, what is your stand?
Yeah, my lord, due to this notification, my lord, of 2013, my lord, this NOC was not given, my lord.
Have you challenged that notification?
Yes, Lordship, we have challenged that notification and since
File your affidavit.
We have not filed.
This
yet, my lord.
notification, I think, has been interfered with by this court.
yes, Lordship, on
Earlier-
several there are many cases where this honorable court has.
Even division bench has interfered, I think.
Yes, Lordship.
So why don't you, how can you adhere to the notification which has been interfered with?
Yes, my lord.
It is a notification having, which applies to all.
Yes.
If we interfere on, it becomes in rem, not in personam.
Yes, my lord.
You advise your clients. We have it after 2 weeks.
Lordship, instead of that, this matter may be disposed of since Lordship, the pension has to be ready and is retiring on this 31st of this month.
Where are the earlier decisions?
Earlier decision, Lordship, I have annexed in my annexer also, there is a similar page 41 and similar.
Dispose of them.
Yes,
Madam?
my lord.
Okay, heard.
V Jammu,
This is item number
11.
Your V Jammu.
Yes, Lordship.
Heard Sri V Jammu, learned counsel for the petitioner. Also heard Ms. Wangmu. T. Wangmu,
Yes, my lord.
learned state counsel representing the respondents. Full stop. Notice of motion was issued.
Instruction, my lord.
Your notice was not
Not
issued.
issued, my lord.
Why is it come for admission then?
Yeah, my lord, I was supposed to get instruction, my lord.
No, why is it come for admission? It is it had to come for motion, I think.
Lordship, on last occasion, the honorable court wanted the matter to be disposed of. but,
Understood, but it is still at the stage of motion.
Mhm.
Actually. No. On 11/1/2024, when this court had considered the matter, the learned government advocate was directed to seek instructions and the matter was fixed today with a further observation that an endeavor would be made to dispose of the matter. Full stop. Para. Such observation was made in view of the subject matter of dispute and also the fact which was taken note of by this court that similar matters were earlier dealt with and disposed of by this court, including an order dated 7/9/2016 passed in WPC 476 AP 2016. Full stop. Para. It is the case of the petitioner that he is a driver in the office of the Deputy Commissioner, Bomdila, in the West Kamang district, who is to retire on attaining the age of subordination on 2014. Full stop. However, with regard to the issue of pension, the NOC/vigilance clearance have not been given to the petitioner on the ground that his wife has occupied a plot of government land. And there was an order dated 25/2/2020 by the Commissioner within bracket Vigilance that that encroachment of land done by the family would also be inferred to have been done by the government servant, government employee. Full stop. The Learned Counsel has submitted that there is also a subsequent communication of 25/2/2020, as per which vigilance clearance would not be given unless the Deputy Commissioner gives a report of non-encroachment by any members, by the petitioners or any of his family members. Full stop. Para. The Learned Counsel has submitted that the issue involved is no longer res integra in view of the law laid down by this court in earlier writ petitions, including an order dated 7/9/2016 passed in WPC 476 AP 2016, wherein it has been stated, it has been laid down that no objection certificate cannot be denied on such a ground. Full stop. In the said order, earlier orders passed by this court on the issue were also taken into consideration. I think there is a division bench also by this court and Justice Sharma.
No, I didn't. Sorry.
There is a division bench. The London State Council, who was granted time to obtain instructions, has fairly submitted that the has submitted that the action of the respondents is based on the earlier notifications. Full stop. She, however, fairly submits that this court has passed judgments earlier interfering with such action. Full stop. Para. In view of the above, this court is of the view that the present repetition be disposed of by interfering with the action of non-grant of NOC/vigilance clearance.
Yes, Lord.
First NOC is there.
NOC to the petitioner, so as to enable himself to receive his post-retirement benefits, including pension. Full stop. Para. Such NOC is accordingly directed to be granted within a period of,
1 week of submitting of this on.
within a period of, within a period of 3 weeks from the date of submission of certified copy of this order. Full stop. Writ petition accordingly stands allowed.
DW.
You are seeking time, madam.
Actually, Your Lordship, the respondent number 1 and 2 have to file the affidavit.
My lord, I'm sorry, my lord, and the order passed by this honorable court has been received by me today only, my lord, this
Okay.
copy.
Okay,
So therefore-
you will seek some time, 2020 matter, why?
My lord, I'm sorry, my lord, this copy has been received.
Which order? Order
Order
dated?
Last order.
5th January, my lord. My lord, 4 weeks time may be granted. In the meantime, my lord, I'll again make correspondence to the ministry, my lord.
It appears that the affidavits have not been filed by any of the respondents. You have filed?
Yeah, state have filed.
Have not, it appears that though the state respondents have filed their affidavit, comma, the respondent numbers 3 and 4
1 and 4.
3 and 4, 5.
are yet to file the affidavit in opposition.
1 and 2 have to file. 1 and 5.
Or the respondent numbers 1 and 2 are yet to file their affidavit. Full stop, para.
Well,
Sri M. Kato, the learned deputy SGI, submits that due to some miscommunication, comma, the instructions could not be obtained.
well,
Full stop. He accordingly prays for and is granted further 4 weeks time to obtain the instructions,
My lord.
last file affidavit in opposition.
deeply obliged.
List accordingly.
Be pleased, Your Lordship. I'm the petitioner. So I have received affidavit in opposition from respondent number 4 and 5. So I'm going to reply reason. The others are not filed, not
The
yet
number
filed.
you have for 4
My
and
lord, I'm for 1 and 2. I'm told that
who is for 4 and 5? Which
I'm
department?
also confused. One.
RTI. RD, Rural Development.
Yeah,
Mr. Tafo,
I'm for 6 months.
file.
No, we'll need time.
private respondent.
Okay. It appears that pleadings are yet to be exchanged.
Yes,
Full stop. List after 4 weeks to enable exchange of further pleadings.
yes.
My lord. Obliged.
Is there any interim order, Mr. Decker? No.
No interim order.
May I plead, my lord. My lord, I am for the petitioner.
Yes, sir.
Here, my lord, private respondent number 4 to 10, service report is awaited.
Awaited.
Yes, and the rest, they have not filed affidavit, my lord.
When did you take steps?
My lord, I have taken a step on 28 or
1/4.
8/6/2023.
1/4/2023. This will not do, you have to take fresh steps. 1 year it has been pending. You take fresh steps and we'll do one thing. We'll list it after 6 weeks. If it does not return, then we may assume service.
Yes.
Uh,
Till then, this interim status quo order may be continued, my lord.
Have you filed your affidavit?
No, Your Lordship, I'm appearing for respondent number 3. I have
Who is free?
I need time.
Who is free?
3 is ADC, Your Lordship.
Okay.
DC, Your Lordship.
Ms. R. Basar, the London State Council, appearing for the respondent number 3, the Deputy Commissioner. Prays for and is granted. Prays for time to file affidavit in opposition. Full stop, para. Office notes reflects that service report upon respondent numbers 4, TO2, 10 are still awaited. Full stop. Such steps, service were dispatched, was dispatched on 1/4/2023, full stop para, in view of the above, comma, let fresh steps be taken for service of notice upon the said respondent numbers 4TO210 by registered post UTAD. Steps within 3 days, full stop. List after 6 weeks along with service report, full stop. It is however made clear that in case the there is no conclusive service report upon the said respondents, comma, this court may pass appropriate orders on deemed service, full stop. Clara, in the meantime, comma, the respondent number 3 may file the affidavit of opposition.
Madam, status order
Para, interim order passed earlier to continue till the next date of listing.
of like,
You take steps within.
my lord,
Take it immediately by tomorrow.
my lord.
1/5.
May I, Lordship?
Yes.
Lordship, I'm for the petitioner, my lord. My lord, matter step has been taken upon private respondents number 4, 5, and 6.
When did you take steps? Taking steps. 29/2023, 10, 11, 12, 1. No, you've taken by usual process. Take by registered post UTAD. Or you have taken registered post also, okay. You have filed your affidavit.
Yes, my lordship.
Respond number, state respondents.
Yes, my lordship.
The state respondents represented by Ms. Sunsu has filed affidavit, full stop para. Office notes reveal that service report for respondent numbers 4, 5, and 6 are still awaited, full stop. The notices were dispatched in September 2023, full stop para. Let last message, huh? वो जो 3 दिन में fresh. अब पहला वाला में जो दिया था. You take fresh steps by registered post daily on this within 3 days and list after 6 weeks. वो जो पहला वाला सब लिखा. Fresh service report and court का presumption भी है. We may deem service. Take fresh steps.
Deeply obliged.
It last line नहीं रहेगा. इसमें affidavit already आ गया. Yes, 16. This one. Where is Mr. Son? None appears for the petitioner on call, whereas the state is represented by Ms. Wangmo, the learned state counsel. File affidavit.
No, my lord, we need some more time. my lord.
Let's see, where is Mr. Kamduk? Whereas D. Kamduk, learned standing counsel land management is also present. Full stop. Para on the prayer of Ms. Wangmo. Matter is adjourned by 3 weeks to enable her to obtain instructions. Let's file affidavit in opposition.
Yes.
Mr. Kato, you are for whom?
I'm for the union Vidya, madam. We don't have any role in the matter.
And Sri M. Kato, learned DS is also present for me.
Madam, DPW.
Item number 19, my lord, by order dated 23/11/2023.
Yes.
I was directed to take steps through registered post and dusty mode, my lord. I have served notice through dusty mode on 13th of December, my lord, and to the effect, I have filed an affidavit on 5th, my lord, 5th of January, my lord.
4 and 5.
4 and 5.
What is your name?
R.L. Thungan, my lord.
R.L.
R.L.
Thungan.
Thungan.
Sri R.L. Thungan, learned counsel for the petitioner. By referring to the additional affidavit, has submitted that dusty service upon the respondent numbers 4 and 5 has been completed, and in this regard, he refers to the affidavit filed on 5/1/2024 in support of such justice service. Full stop para. The service upon the said respondent numbers 4 and 5 is deemed to be complete. You have for all the three respondents.
No, Lordship.
You have filed affidavit.
No, Lordship, we have been asked to take instruction. So we sought for instruction and instruction was received, Lordship.
And then, what is instruction?
Uh,
Are you required to file affidavit? Will you file affidavit or not required? On based on the instructions, can you take it up?
Lordship.
Basic contention, my lord, in my writ petition is that my inner permit was cancelled in gross violation of principles of natural justice, my lord. On
What is your take? What have you said? What is the instructions?
Lordship, can I go through a bit also, Lordship?
You tell us.
Lordship, in this bit, of course, what the allegations are not denied, Lordship. In the instructions, there has been some violations was there, Lordship.
Then we'll not record your submission, but we can refer to the Sri Tungan, the learned counsel, submits by referring to the order dated 23/11/2023 passed by this court, has submitted that the matter is of serious nature, wherein the ILP of the petitioner has been seized and cancelled, and the petitioner has been exterminate. What it has been exterminant,
externed, my lord. It would be externed, removed from.
and the subsequent exterminant of the petitioner and his family members from Shanglam. Yeah, the line is not complete. What did he say? Exterminated from petitioner and his family members have been exterminated from Changlam. Full stop. This court has also recorded that such action appeared to be in derogation of the established procedure of law. Full stop. Para. Sri so-and-so learned State Council has submitted that written instructions have been received, which have been placed on record. Full stop. A perusal of the said instructions would show that the impugned action is not preceded by a due process of law, as adequate opportunity as required have not been given to the petitioner. Full stop. In matters of the present nature, which involves seizure and cancellation of ILP, the basic rights of the petitioner who has been residing in the state are seriously threatened, and therefore it is incumbent upon the authorities to ensure that the due process of law is followed, which apparently has not been done in this state case. Full stop. Para. In view of the above, and taking into consideration the written instructions placed on record, the impugned order dated 6/10/2023 passed by the Deputy Commissioner Changlang, whereby the ILP of the petitioner has been cancelled and there was a direction for seizure is set aside. Full stop. Consequently, the seizure memo dated 7/10/2023 is also interfered with. Full stop. It is, however, made clear that interference of this court shall not preclude the authorities to initiate a process recognized by law for such action.
Much obliged.
The copy of the written instructions is made part of the records. We retain this. Hearing. 17 matter, Mr. Deori, what is this?
My lord, this land of the petitioner was required. Compensation for the land has been paid, but the crops standing therein has not been paid.
Jida.
Yes. This is a community land.
Yes, what do you see?
My lord, so far my lord, private property is concerned, my lord, district administration, they will pay. Perhaps they have paid. What exactly they are asking, my lord, they are asking for the deforestation, that amount was given to the government. The share that they are asking for that. That is, my lord, comes under Kempa. So when you say Kempa, it's a central, my lord, we are just a coordinator, my lord. So amount has been deposited in the Kempa, my lord. So from that, my lord, deforestation compensation, they want share, my lord, which cannot be done, my lord. Because
Are you entitled to deforestation?
No,
No.
this is our land, my lord.
even that,
Plant were the trees which were this extracted has been planted by us, by the society,
But-
under a joint venture with
but report
government.
says, my lord, there, my lord, after certain period, there was no any plantation they carried out, my lord.
There is no dispute that land is not belongs to us. It is a community land.
No, Mr. Deori,
My lord.
this aspect, isn't it concerning the factual element? How do you
Yes.
prove if the learned AG is saying that there that after one point of time
Yes.
there was no plantation, and you say on the contrary that there was plantation? How do you prove it?
No. Earlier there was no plantation. This is our cultivation land. When it is not suitable for cultivation, we took a resolution, community took a resolution that land should be converted for, shifted for this horticulture cultivation. Then government, there is a proposal come from the government that we will make a joint forest, blessed joint forest. And accordingly, we have planted the tree under the scheme of government. Government has also afforded some financial help has given.
So
Now,
that aspect, if it is disputed by the state, how do you prove it in a writ court?
My lord, agreement
lord-
was carried out 1997.
yes, my
And
lord,
as per the report submitted by this one is Chief Conservator of Forest, 2016, my lord. It says, my lord, no plantation was carried out, my lord. After that, long time, my lord.
if there is a no plantation, my lord, how they have been extracted 3,000 or 6,300 something trees, my lord. Kindly see the, my lord, please. I have made a list of dates, man.
Twenty-one is also similar.
Yes, no, my lord.
21 is different, my lord, it's a
21 is
compensation. My lord, basic question whether they are entitled to
Page
that amount
60
or not, my lord.
Page 67, your lordship.
6-7.
Annexure 9.
What is NPV?
NPV, net
Net-
present value of the trees.
NPV, net
Yes, net present value of trees. My lord, the allegation is that the contention is that we have not planted trees. My lord, kindly see page 67 of the writ petition. Number of
Have you
project-
filed a representation to them?
Yes, my lord.
They have denied.
No, till that decision has not been taken. It was forwarded to the chief conservator of principal conservator of forest.
Mr.
My lord,
My lord, basic
Annexure
agreement
13.
was drawn, my lord. Whatever business
Even-
transaction
No,
is
no,
done,
no.
Mr. Nabam, we are just thinking, if these aspects, see, these are having factual disputes.
disputes
So
are
there may be some problem for us to embark on these disputes,
right, my lord.
factual disputes. But at the same time, we find that they had approached the authorities by filing a representation. You could have considered the representation, pass speaking order.
Even DFO also forwarded and asked that, my lord,
If you say
requested.
that they are not entitled to give the reasons,
Yes.
at least we can examine the validity or otherwise of the reasons, then it becomes matters which we can at least embark upon.
My lord.
Now, even if he has a case and after 2017, Suddenly saying that not maintainable may not also be too good, proper,
Lord,
at this stage of hearing.
my lord. But I'll not harp on that, but as per the agreement drawn between by the petitioner and the government, my lord, the business transaction carried by both, out of that business profit, 25% they are entitled, my lord. When, my lord, business was not carried out, the question of, my lord, getting share is does arise.
Okay,
And
where is that?
my lord, your lordship may kindly see the agreement, my lord.
Are you basing your claim on the agreement?
Obviously, this should be based on the agreement, my lord.
No, my lord, we have planted the tree on our own land. This is not a reserve forest. If it is.
No,
reserve-
is your claim based on an agreement?
Yes, my lord.
Then if you have not made any business, how do you get?
No, as per the resolution taken by the society, we have planted the tree, taking aids from the
Have
government.
you filed your affidavit, Mr.
Yes.
Abram?
Yes, my lord.
Have
we
you
have
said that there was no business?
Yes, my lord. In the agreement, my itself says, my
No,
lord.
agreement.
No.
25% of the business.
Yes.
Have you stated in your affidavit that there was no activity of forest so that 25% can be ascertained?
My lord, what we have said, my lord, the amount which you have received from the this NSPC, my lord, it's against the, my lord, forest, against, my lord, this deforestation, my lord. It's a compensatory, my lord. When compensatory comes, my lord, there is no business, man. So there is no any business transaction. So this amount is only for the, my lord, reforestation, and that is deposit under the
Afforestation.
Yes, my lord. So exactly, they're
It is
asking money in
regarding,
that
my
part.
lord, if that this tree is falls under a reserve forest, then it will go to the compartment. Now we have planted this tree under a joint venture with the government, under the aids of government. There are 6,133 plants have been extracted. My lord, page 67. This is their report. Report of the Divisional Forest Officer, page 67, Annex 9.
67. Right.
Yes, ma'am. This was furnished through an RTI application. Point number 1, actual area acquired by the Athena hydropower project from the Kennedy Community Forest area is 310.47 hectares. Copy of working scheme and close. Number of
Regarding payment.
number 2, number 1.
Number 1, actual area.
Yes, madam.
Yes,
Actual
yeah.
area is 310.47 hectares.
Yes.
Madam, number 3, number of project affected trees, 6,133 numbers. And royalty of the project affected, so and so, madam, and the amount of the NPV paid by the user agency is 22 crores 66 43.100. This is their report, my lord. They have now said we have not planted tree.
This net present value is for the plants
Trees.
which have
Plant
been
we have been-
uprooted.
Yes. Plant we have uprooted. On this 310
From this amount,
hectares of
will
land.
not they be entitled to any portion?
My lord, they are not entered because this is not concerned to any business transaction, my lord, as per the agreement, my lord. This is purely on afforestation, reforestation, my lord. That's why, my lord, entire money has been deposited under Kempa, my lord. And that too also, my lord, as per the Supreme Court order, my lord. All this deforestation MI has to be deposited in the Kempa, my lord. That is the basic.
No, this amount of 22 crores or whatever,
Yes,
is it
sir.
for afforestation or is it the present value
Of the
of
trees.
the trees which have been affected?
My lord, both, my lord. Both, my lord. Because, my lord, once, my lord, tree is uprooted, definitely, my lord, that will be. Now, what?
Okay, let's come back at 2 o'clock.
2 o'clock. My lord, what we are saying, my lord, these are the forest. Is already existed, my lord. The agreement was drawn. Whatever new forest, my lord, plantations done, out of that business transaction, they will be entitled for 25%, my lord. Now they have to show, my lord, that 360.33 they have planted, my lord. Now they have to satisfy your lordship.
You mean to say that these are already existing trees,
Yes.
not planted by them?
Not planted by them. If they can produce any document that these are the tree they have planted money, yes, my lord.
What is the next item, Mr.?
My lord, next item is also land was acquired for construction of law college. Compensation has not been paid. This is a private land.
Acquisition proceedings.
Yes.
What do you say there?
So I'm not there, my lord. Or else, my lord, this matter, your lordship may remand back to the authority since they have submitted the representation. We is speaking whatever
Yes, my
that can be
lord. The
discussed.
deputy, the DFO also repeatedly requested the PCCF.
Now we'll take it up to, because
My
we
lord.
want to record some of your submissions. You are saying you're raising some factual disputes.
My lord.
These are existing trees, may not be planted by them.
Yes.
And these matters needs to be taken into account by the authority who consider the representation.
My lord. I drop, my lord.
Okay.
See, my lord, the last paragraph. This refers to that original regulation with the petitioners, my lord. Has your lordship got it?
Yes.
My lord, may I read? As per regulation passed by the government on JFM scheme by number so and so dated 3/10/1997, it was stated among the others condition that the revenue accruing from the timber operation, your lordship may kindly mark, timber operation, both at the time of silviculture, thinning and the main felling shall be shared between BFMC and the department in following manner. 50% of the gross revenue shall be credited to the government account as a revenue, while from the remaining 50%, 20% will be distributed among all the members of the BFMC concerned, and the balance 25 will be deposited in the development fund. So meaning thereby, whenever there is any business transaction, they will be entitled for 25%. My lord. Now it also further says, my lord, will be shared by the Operational Executive Committee for Development Activity as approved by and endorsed by the governing body. The revenue such as from levy of fine extra will also be credited to the government fund. But this is very important. But as on that, no plantation regeneration under FDF, that is Forest Development Authority, was taken up in Kenny Community Forest as per letter dated. As per letter of DFO Namsai letter dated, sorry, it's a 6/1/2016. So till 2016, there was no plantation, my lord. That is the communication made by the Chief Conservator Forest. That's why I said, my lord, what they are saying, 6,133 they have planted, my lord, which may not be correct, my lord, as per this communication, my lord. So may I suggest, my lord, since representation is pending, if you lordship, my lord, that can be with a direction to dispose of the representation with proper my speaking order. That can be done.
I think that's a good suggestion.
Yes, my lord. If we have not planted the trees, my lord, kindly see page 41. This is the photograph.
No, photographs is of existing trees.
Yes. And also, my lord, report of DFO, page 54.
This is only for that perhaps will not be covered by this. Okay, nonetheless.
Yes, my lord. Like some backside, it's unclassified. Obviously, there will be 3, my lord. It's unclassified forest area.
Page 54, my lord, this density of the forest.
Where is the representation?
My lord, annexed this
Page?
page 10 is also, it was, they have stated in the first paragraph.
No.
Page annex 10 also, they have received page 68.
That is the representation. Where is the
No,
representation?
it is the, on the basis of my representation, they have forwarded this to the principal conservator of forest. In the first paragraph, it is written, I am forward here with the representation that is 16/9/2014, copy and close.
Where is that?
Received and one more is there, Alex, this one, annex 11. page 70.
SK Dury, learned counsel for the petitioners, R.H. Nabam, the learned additionally the Arunachal Pradesh, for all the respondents. This is for hearing, I think.
Yes,
No, as agreed to nature. The petition numbers 1 and 2 are no, the petition number 1 is a society, the petition number 2 is a committee, and the petition number 3 is a resident of the concerned location and is connected with and is the chairman of the petition numbers 1 and 2. Full stop. It is projected on behalf of the petitioners that they possess community forest land measuring 310.47 hectares and had formed a joint venture forest management committee with the aid of the forest department for preservation and conservation of trees. Full stop. As per the petitioner, out of the revenue, 25% was to be distributed, would be the share of the committee. Full stop. Pursuant to a notification dated 19/11/2010, the land in question was acquired for construction of a hydropower project, and the concerned company, namely Messrs. Athena DEMWE, Demwe Power Limited, had deposited an amount of rupees 22,73,58,458.50 as compensation by the user company. Full stop. According to the petitioner, such amount would also cover the extraction cost of trees, revenue earned from the extracted trees, and net present value of the affected trees. Full stop. The petitioners had accordingly served notice to the authorities for release of their share, which was refused, and accordingly the present petition has been filed. Full stop. Sri Deuri, the learned counsel for the petitioners, has submitted that there are materials in record to show that the petitioners are entitled to petitioner's claim is legally maintainable as per the arrangement by which, 25% of the proceeds were to be given to the petitioners, full stop. It is submitted that apart from photographs of the existing trees which were affected, the communications, inter-office communications would also suggest that in the process of construction of the Hydel project, there were many trees which were uprooted and otherwise affected, which were planted by the petitioners, full stop. Sri Deori, however, fairly submits that the present claim is only limited to the value of the trees, and otherwise the compensation for the land in question has already been given, full stop. Para. Sri Nabam, the learned additional AG, however, submits that the claim is both legally and factually untenable, full stop. He submits that the forest in question was an unclassified, that the area in question constitutes unclassified forest, full stop, by referring to the annexure,
Page 68, madam.
annexure 10,
Yes,
which is a communication dated 11/2/2016, issued by the Chief Conservator of Forest, Eastern Arunachal Circle, to the Principal Chief Conservator of Forest, Arunachal Pradesh, the London State Council has emphasized that the said communication would make it clear that as on the date, there were no plantation / regeneration under FDA, which was taken up in the Kandy Community Forest. Full stop. He submits that the said communication had emanated from a representation dated 16/9/2014, submitted by the petitioners themselves, and therefore their claim does not appear to be sustainable. Full stop. The London State Council has also raised the issue of maintainability of the writ petition itself, as it involves factual disputes. Full stop. Para. After hearing the parties and on consideration of the rival submissions, this court is of the opinion that though a writ court is not, does not have the expertise to enter into factual disputes, at the stage of hearing of this writ petition, which was filed in the year 2017, dismissal on the ground of maintainability may not be proper or justified. Full stop. At the same time, the existence of disputes which are factual in nature cannot be totally overlooked by this court. Full stop. Para. This court has noticed that the communication dated 11/2/2016 is upon a representation dated 16/9/2014. Full stop. The petitioners have also annexed another representation dated 13/3/2014, which has been annexed as Annexure 11. to the writ petition, full stop. Para. Under those circumstances, comma, this court is of the opinion that interest of justice would be served if a detailed and speaking order, if a detailed consideration is given to those representations are disposed of by a speaking order, full stop. The aspects which have been highlighted on behalf of the respondents are also to be taken into consideration while considering, are also to be taken into account while considering the representations by the appropriate authority, full stop. Whom do you direct?
Principal Malad,
Principal. Sir.
Principal Conservator of Forest.
The said consideration be made by the principal chief conservator of forest,
Forest Malad. Yes.
Arunachal Pradesh. Full stop. To facilitate such consideration, comma, the petitioners are directed to furnish fresh copies, fresh only duplicate copies of the representations, along with other relevant documents in support of their prayer within a period of 3 weeks from today, full stop. From full stop. This the efforts, the consideration as directed above is to be done thereafter, and speaking order be passed within a period of 2 months from the date of receipt of such representation.
Yes.
Such duplicate copies of the representation. Representation can dispose of.
21, my lord, last occasion it was directed to obtain instruction what step has been taken.
Yes,
in-
madam.
Instruction was regarding if the department can provide the service of the group C or D.
You had made some acquisition for the law college.
Yes.
Then you have not paid the compensation.
It is acquisition, but then they said we are already so.
No.
In the beginning, also. They
In,
said
in the beginning, my lord, the fact is that in the beginning, we have agreed to donate the land. In lieu of compensation, they should provide us a job to the family members. To one is from the family, there is 2 petitioner only. One is from the petitioners, family. Only 2 petitioners. There are 19 acres of land has been acquired. Law college was established. Now, nothing has been given. They contended that we have provided some contract work, but the PW said the contract was given as per the CPWD manual on merit.
because they are the donor, they have been provided work was one was given more than.
See, madam, you cannot force a person to donate his land.
Yes.
No.
He they donated with some expectations. Of course, whether such expectations are enforceable, that's a different matter. But having a practical view of the matter, and this is 19 acres of land, which is not a small area. So if they are retracting their donation part, then you have to pay you cannot get land for free. Do you expect that all land would be donated to you?
In the beginning, there was, their condition was that job and then this one, work. The work as such we have given on the papers.
Well, they must have emerged as L1.
And then job also the last. Okay, the court asked if you should consider on that subject. Also, I have a.
Instructions.
No, also I have conveyed the responding officers. So they have said they have given me the letter that they have, that the commissioner, he have conveyed the letter to the government.
If you give them the job, perhaps he'll not insist upon.
Yes.
See, this part, it is not legally enforceable. You cannot have a, it's not a quid pro quo that you give me a job, I give you land. That's not recognized by law. But as a government, you can do that. We cannot say anything on that. Okay, you have the instructions, but 18 matter, come back early, 18 matter.
Yes.
2018 matter, we'll give you some time, but don't take too much of time, okay? Bring it to a logical conclusion, either yes or no. If no, then we'll decide their entitlement for compensation. If yes, the matter ends perhaps. No, see, the part of consideration is presently with the government. Deputy Commissioner, whoever the incumbent might have been, he has already sent the proposal. So whoever is the new incumbent will not make much of a difference. If you make a decision in principle, you convey to the Deputy Commissioner, matter ends there. Which was the order, last order? First, this court has been apprised that there was a move for consideration of the case of the petitioner. And on the last occasion, that is 30/11/2023, the learned counsel for the parties were given time for taking appropriate steps. Full stop para. MS G. Ete, the learned additional senior advocate, Arunachal Pradesh, has submitted that the matter as to whether a job can be offered to the petitioner, to either of the petitioner, is presently before the government. And the outcome is still awaited. Full stop. Full stop. See, accordingly, prays for and is granted further 3 weeks' time to get the instructions. Full stop. List on, should we fix a date?
Yes. 15.
Because 18 matter.
16.
List on, tell us.
16 February.
Today is what?
16 February.
It's not, we'll have it on 27th. 27th February. Okay? Enough time you are getting.
Apply.
Yes,
May I please, my lord?
yes, please.
My lord, in this instant writ petition, I have put to challenge the impugned cancellation of NIT dated 25/2/2021, which was for construction of Kaing Township Road, amounting to approximately 15 crores, lordship. Lordship, and then impugn fresh NIT dated 28/8/2021.
Is there an interim order?
Lordship, there's interim order.
Okay, the fresh process has not progressed. There is a halt.
The NIT was failed to NIT could not proceed.
Since in interim was it was specifically directed that not to finalize the NIT.
Okay.
They have proceeded with the process, but they have not
not
finalized
finalized.
it. That is the issue.
Okay.
Now, lordship may allow.
We decide this,
Lordship.
because otherwise, if he,
May I proceed, lordship?
yes, please.
Lordship, the impugn cancellation order, which I put to challenge, is at page impugn NIT is at page 49, annexure 10. Impugn cancellation is at page 50, annexure 11.
Just a minute, please.
Page 50 is the impugn cancellation of tender.
What is the work about?
Lordship, for construction of Kaing Township Road. Lordship.
Where is it? NIT?
NIT, the NIT is at
Is it at page 38?
Lordship, NIT is at page, yes, 36 to 42, Lordship. Annexure 6 of my writ petition.
36.
Thirty-six is the NIT, Lordship.
NIT, okay.
Yes, 25 to 2021.
This was cancelled.
Yes, Lordship.
This has been cancelled.
This has been cancelled
25
to 2021.
NIT. Okay.
White order dated 6/8/2021, which is at page 50, Lordship.
For Kaing Township Road Network. Okay, you participated.
Yes, Lordship. And subsequently.
You are a company.
Lordship?
Are you a company or
Yes,
individual?
+1 contractor, Lordship.
No, you are a company or individual?
Proprietorship.
Proprietorship.
Yes, Lordship.
What is your name? Agency.
At
Okay.
ASEAN agencies.
Petitioner is the proprietorship firm.
Yes, Lordship.
Firm. Okay. You participated.
Lordship.
Thereafter?
Lordship, before going to the instant NIT, I would like to briefly highlight the facts leading to the filing of this case.
Yes.
Lordship, what it happened in the year 2019, two packages were issued for the said work, which is at Annexure 2. The NIT was called for package number 1. Initially, this particular 15 crore, Lordship, it was a splitted package, Lordship. It was around page 32 is the initial NIT, Lordship. This page 32 is for construction of Kaing Township Road Network. Package 1, change number 0.00 km to 2.482 km, which the amount cost of a tender was around 7 crore 7 lakhs to 23,008, which is at page 32, Lordship. This is with respect to package 1. Now, with regards to package 2, Lordship, it is at page 33, Lordship. It is at page 33, Lordship.
This is package 1.
Package 1 is page 32 and package 2 is page 33, Lordship. So this NIT dated 15/7/2019, it was called, and class 2 contractor were invited in the tender, Lordship. Now, what it happened, Lordship, after this particular
Just a minute. This is also more than around 7 crores.
Yes, Lordship.
Okay. Yes, thereafter?
Now, Lordship, thereafter, in the NIT, Lordship, it can be seen in the NIT that only class 2 category, civil category contractor were invited. So accordingly, the petitioner, and during that point of time, Lordship may kindly note that during the point of time, the beyond 10 crore, Lordship, from 5 crore to 10 crore, only class 1 contractor were eligible. And from 3 crore to 5 crore, Lordship, class 2 contractor can participate as per the District-Based Entrepreneurship Act at that relevant point of time in the year 2019, Lordship. So now, since this particular amount was put to tender falls within between 5 crore to 10 crore. So the respondent authority ought to have invited the class 1 contractor. However, they have invited the class 2 category contractor. So accordingly, the petitioner, being the class 1 contractor, they have protested, and in fact, they have participated. Since they are the class 1 contractor and the amount cost put to tender is 7 crore.
More than 5 crore.
Yes, more than 5 crore. Now, what happened, Lordship? Thereafter, subsequently, the NIT was cancelled, Lordship. The NIT was cancelled, and then these two works were clubbed together, Lordship. the NIT was cancelled by, it's at page 34, Lordship, Annexer 4. NIT was cancelled. And thereafter,
This is
Lordship,
what, the date 58.
5/8, Lordship. 5/8. After that, Lordship, it was, the same was clubbed together, Lordship. Now, Lordship.
Club
the-
together in page 36.
Yes, Lordship. It was clubbed together and the package, the 7 crore becomes 15 crore. Now it has become 15 global tender, Lordship. At that point of time, it was 10 crore. Now, Lordship, why I am mentioning all those things, Lordship?
Just a minute. Yes.
Now, Lordship, we have challenged this particular amalgamation of the two project, Lordship, before this honorable court, and subsequently, this honorable court was of the view that since the chief engineer is the technical sanction authority, then it has the power to either club or split the project. So that was the view of this honorable court. So accordingly, the case was dismissed.
You had initially challenged this 25-2.
No, Lordship, the previous NITs. The clubbing of that previous NIT. I'm just
That is 25-2.
25-2 is the fresh NIT, Lordship.
That this has been clubbed already.
Yes, before clubbing, yes, Lordship. The clubbing order that order dated Annexer 5. We have challenged that Annexer 5 before this court. And then accordingly, that was the repetition was dismissed on the ground that
Your letter number so. Your director submit single draft NIT for the same project.
yes, Lordship. Single. So since
Just a minute. No, this does not talk about any clubbing at page 35.
yeah, yes, Lordship, it has directed the authority.
Where?
You are directed to submit a single draft NIT for the said project to the office of at the earliest. So this along with, there was another order, Lordship, clubbing order, which has inadvertently.
Okay, doesn't matter.
Yes, Lordship. Now, after this, thereafter, Lordship.
Earlier, petitioner, chairman. Petition was dismissed.
Yes, Lordship.
There, they clubbed.
Yes.
Then page 36, 36 was issued.
Yes, Lordship.
Okay.
Now, page before that, Lordship, before the issuance of why I am narrating all this, Lordship, just as before, Lordship, I have again made the Honorable MLA as a party in this instant writ petition, Lordship. Now, what it happened, when this particular, since there is only 2 class 1 contractor in the entire Siang district, Lordship. Now, if the project is clubbed, then it will be a global tender. So why the project has been clubbed? By calling class 1 contractor, although that is not material anymore. However, Lordship, page 36 was issued. The Lordship may kindly note the time gap, Lordship. This particular clubbing order was issued on 5/8/2019. And the press NIT was called on 25/2/2021. Now, why I am pointing out this date, Lordship? This was supposed to be the respondent authority was trying to plot this as a global tender. However, in the meantime, there was an amendment in the District-Based Entrepreneurship Act that was in the month of November 2020, Lordship. So as per that amendment, the cost of tender up to 20 crores was made under District-Based Entrepreneurship Act. Basically, the bidding capacity of class 1 contractor of district-based was enhanced to 20 crore, Lordship. So finding no alternative,
Yes.
Page 36.
Yes. Yes.
Serial number 6. Milestone date of e-tender, and within serial number 6, serial number 7, date of opening of technical bid, Lordship. 12/3/2021, Lordship. Now, Lordship, 12/3/2021, technical bid of the farms were open, Lordship. Now, after
One code, you know. This is divided.
Lordship,
Yeah.
technical bid was
12/3/21 was the date of opening of the
technical bid. Now, after that, Lordship, there was no result of the financial bid, Lordship. It was just kept in abeyance for whatsoever reason. Later on, Lordship, the petitioner came to know that, Lordship. May I take Lordship to page 52, Lordship?
52.
Yes, Lordship.
Yes.
The page 52 is the cancellation of enlistment of the contractor, Lordship. This is the cancellation order of Messrs. Ornachal Engineering Construction, Lordship. Now, one of the participant farm, which is the proprietor of the farm, is the spouse of the honorable local MLA. This enlistment was cancelled, Lordship. Now, since the enlistment of the of Ornachal Engineering Construction was cancelled, Lordship, they could not proceed further. If they proceed further, they have to award the contract to the petitioner or some other farms, qualified bidders, Lordship. Now, what they did is, Lordship, after the bid was open, they have kept the tender in abeyance for almost 6 months, Lordship. So accordingly, the petitioner, along with co-bidders, has made a representation before the authority on 24/8/2021, Lordship. Now, despite the submission of the representation, neither they have furnished any reason for such cancellation. Accordingly, being aggrieved by the same, the petitioner has approached.
Where is the cancellation?
Cancellation, Lordship, cancellation is at page, Lordship, page 50.
50.
Yes, Lordship. 50 is the cancellation, Lordship. Now, this particular farm was cancelled. Then enlistment of the farm was cancelled. Again, then since the enlistment.
Non-responsive, of course. No. You have to be non-responsive.
Yes, Lordship. I'm coming to that, Lordship. Now, since the enlistment of the farm was cancelled, that is the reason why the entire tender process was cancelled. So accordingly, I have approached this honorable court and honorable court was pleased to stay the tender, Lordship, not to directed not to finalize the tender. Now, as per the reply, Lordship.
Yes.
Now, as per their reply, Lordship, as per their affidavit in opposition, Lordship, despite submission of the RTI application, they have never furnished the reason for cancellation or reason for being found non-responsive. Now, as per their Lordship, as per their affidavit in opposition, may I take Lordship to page
3 of their affidavit in opposition. May I read, Lordship?
Affidavit of opposition by respondent number 4.
Yes, Lordship. Affidavit filed by respondent number 4.
Yes. Page?
Page 3, Lordship.
Yes.
They have respondent number 4 has shown the reason for being non-responsive, Lordship. May I read, Lordship?
Yes.
During detailed technical evaluation, page 3, Lordship.
Yes.
Page 3.
Yes, during detailed
Yes,
examination.
Lordship. During detailed technical evaluation, all 4 bids were found to be substantially non-responsive on technical ground. The reason for disqualification of the bids on technical ground are as below. Now, number 1 is the petitioner, Lordship, Messrs. ASEAN Agencies, Lordship. The firm has submitted only one ongoing works in the bid, that is road infrastructure development of so-and-so, amounting to so-and-so under Rumgong Public Work Division. However, the firm is having 4 ongoing works under PWD as on the last date of the submission of the bid and concealed the information about their ongoing project so as not to get disqualified under the Arunachal Pradesh District-Based Entrepreneurship and Professional Act. The name of the ongoing work has been undertaken by the firm are as follows, Lordship. Construction of PLK Road under Pasigat Public Work Division. Construction of composite bridge over River Sisar at 14 kilometer on Dambuk Paglam Road. Improvement of Siluk to Ngopuk Village under Pasigat Public Work Division. Construction of Dambuk Paglam Road under Rowing Public Work Division. So this was one of the ground where they have the respondent number 4 has said that it has not disclosed 4 ongoing works. Now, another aspect is, Lordship, the firm has failed to fulfill clause 1.4 section 2 of the bid documents for information on qualification by not furnishing correct information on ongoing works, committing a commitment resulting into inefficiency in assessment of their available bid capacity. Now, assessment of available bid capacity of the bidder is very important factor to find out his capacity to undertake any work if awarded to him. In this matter, it can be clearly referred to clause so-and-so in section so-and-so, instruction to bidder of the bid documents, where it states that in no case the contract shall be awarded to any bidder whose available bid capacity is less than the evaluated bid price, even if the said bid is lowest evaluated bid. The contract will, in such case, be awarded to next lowest bidder at his evaluated price. Therefore, correct assessment of the available bid capacity is of paramount importance while awarding the contract. However, in the instant case, the tender evaluation board was unable to access the available bid capacity of the bidder in absence of correct information furnished by the bidders. That further in clause 4.5.10, disqualification of section 1 of the bid documents, the terms and condition of the disqualification of the bidder has clearly been mentioned as reproduced below, Lordship. Bidders have submitted affidavit for correctness of the bid, stating that all statement made and information furnished in the bids are true and correct to the best of their knowledge. Hence, the bid submitted by the petitioner was rejected for concealing the truth, facts, and submission of false statement. The firm has failed to qualify for the duly countersigned by the concerned superintending engineer and chief engineer, Lordship. Now, that in this connection, the format for affidavit has been specifically prescribed in bid documents to facilitate all the bidders for not committing the same mistake. However, the affidavit submitted by the firm has been executed for not engaged in more than 3 numbers of tender work in hand. Apart from this, the firm has concealed the information about their ongoing works in hand so as to mislead the tender evaluation board and get the tender awarded in a fraudulent manner. As such, the affidavit submitted by the firm was found out to be false and misleading. It is pertinent to mention here that the above stated eligibility criteria under Arunachal Pradesh District-Based Entrepreneurship Act is a mandatory and prerequisite eligibility criteria followed by the state government, which is applicable to whole of Arunachal Pradesh. Failure to meet the criteria laid down in this act is non-rectifiable and irreversible defect. Hence, the tender evaluation board has followed the laid down norms of the state government and in no way jeopardized the fundamental rights of any bidders. And number third is, Lordship, the police verification certificate furnished by the firm was also found has expired as it was issued more than 1.5 years before the last date of bid submission. Now, this was the ground for rejection of the purported ground for rejection of the bid of the petitioner, Lordship. Now, Lordship, before moving to the very pertinent issues, I'd like to point out the issue number C, Lordship, police verification. Police verification, Lordship, normally this person, petitioner, does not have any criminal antecedent, so it does not hold any ground, Lordship. And
whether you have or not, only for that purpose.
no, the documents I have, Lordship, submitted, Lordship. The documents, it does not, it is not substantial to affect the bid process, Lordship. Since I have submitted the verification, Lordship, number one. Now,
No, if police verification, if it is required, it has to be a current police verification.
Lordship, that has been submitted, Lordship.
It is 1.5 years back.
Lordship, it has not been specified, Lordship.
That been specified 1.5 years back.
No, that 1.5 years has been specified here, but in the tender documents, it is simply police verification, Lordship.
So this is a normal inference.
Yes, Lordship.
Police verification has to be of current date.
Lordship. No.
You may have a very good antecedent.
Yes,
but
Lordship.
yesterday you have committed something. How will the authorities know?
Yes, Lordship. Now, Lordship, with regards to the important issues, now with regards to 3 works in
Counsel, see, we have just had a cursory glance.
Yes, Lordship.
They have cited reasons for cancellation of not your bid only.
Yes,
They
Lordship.
have cited reasons for cancellation of all the 4 bids.
All the 4 bids, yes.
And they have resorted to a new tender.
Yes, Lordship.
You are aggrieved by the cancellation process as such.
And the fresh tender, Lordship. Subsequent
Obviously,
fresh
fresh
tender.
tender.
Yes.
Your challenge has to be confined only to rejection of your bid.
Yes,
You
Lordship.
cannot go into the bids of others. You do not know
Yes, Lord.
whether the reasons prescribed are germane, relevant or not. If the reverse would not have been correct, if you think or if you know that the bid of some other competitor was not qualified, it was having some defect, then you can point it out. And if they have not regarded, you can say, no, these are the defects they have not pointed out. Now, they on their own have scrutinized each and every bids, come to a conclusion that the bids are somehow suffering from defect.
Lordship.
And under those conditions, a fresh tender has been issued.
Yes, Lordship.
Now, what is the legal prejudice you are suffering? Are you debarred from participating in the new tender?
Lordship, I'm not debarred from participating in the
That's
new
number
tender.
1. Number 2, what is the legal right of yours which has been violated?
Lordship,
Law is very clear that cancellation of a process, they are not even required to assign reasons. Yes, cancellation of your bid and holding somebody to be responsive,
Lordship.
you can challenge. But here, even such detailed analysis is perhaps also not necessary.
Lordship.
They may have some good reasons for cancelling the process.
No, the basic reason, Lordship, here, which they have pointed out. I mean, there are some other reasons also. The basic reason is that I have not submitted I have not disclosed the ongoing works properly. I mean, I have disclosed only one ongoing works, whereas there are some 4 numbers of ongoing works that I have not disclosed. Now, that with regards to that, Lordship, that this.
No, Mr. Tapa, there'll be another issue.
Yes, sir.
Suppose you satisfy to convince us
Okay.
that your bid has been rejected, and the rejection of your bid is not lawful.
No, sir.
We are convinced that your bid should have been accepted.
Yes, sir.
You cannot argue on the bids of the others.
Yes, yes.
You can satisfy that your bids, and we can also hold that your bid is a valid bid. They should have accepted.
Lordship.
Now there remains a position where only one bidder would be there.
Yes, Lordship.
Under those conditions, whether they are allowed in law to go ahead.
Lordship, since this is
Under the CVC guidelines, if for the first time, if there's if a situation emerges when only one bidder has been found to be technically responsive,
Lordship.
then you cannot go ahead.
Lordship, this is second call, Lordship.
No, first was not cancelled because of single bidder. The CVC guideline says that if there is an emergence of a single bidder in the technical stage, for the first time you have to cancel. If it again emerges in the second time, then you may go ahead. This is only to avoid any cartel or any monopoly kind of thing.
Lordship.
Here, even if assuming that you are successful in convincing the court that your rejection is per se not sustainable in law,
Lordship.
but that will not give you any benefit because it will emerge a situation of one tender. You
Lordship.
cannot go ahead.
Lordship, the issue is since the previous, even this is the second call, Lordship. Now we have challenged.
As I have already clarified, previous does not appear to be because of one single bid.
Lordship.
Previous was because of some other reasons, and you had already, regarding the amalgamation, clubbing, you have already unsuccessfully come to this court.
Yes, Lordship.
Now, you cannot go back to those issues, already decided.
Lordship.
You said that I have participated, they have cancelled, cancellation is not in accordance with law.
Yes,
We find that the cancellation is for the reasons that all the 4 bidders have been found to be technically non-responsive.
Lordship.
You can argue on your own case.
Yes, Lordship.
We hold that you are technically responsible.
Lordship.
Can you get any benefit?
Lordship. With regards to other bidders, I cannot.
You cannot. They have not before this court.
Lordship.
If somebody else would have come, no, I am also there.
Lordship.
Examine my case also.
No, sir.
You find 2 of the bidders are to be technically responsive. Their cancellation is not proper. Then we could have said that open their financial bids, give it in accordance with law.
Lordship. But here we cannot challenge the
You cannot.
ground for. Yes,
You
Lordship.
cannot.
That is true, Lord.
And these matters, which you have, you're trying to build up a case, develop a case,
Yes, sir.
that these grounds which are cited may not be correct.
Right, sir.
This prima facie, this grounds appear to be have some reason, some basis.
Lordship.
There may be some, suppose the argument which you have just made on the police PVR.
Lordship.
You say that tender condition did not specify that it should be a recent PVR. We may not argue. Maybe the other factors are also there. They said that you have concealed certain works which are ongoing works. You might have said that those were over or those will not have any impact on the bid capacity.
Lordship.
Those are probable, maybe your probable arguments.
Lordship.
But worst case or best case for you, we hold you to be technically responsive.
Yes.
Will you get anything?
That is the issue, Lordship.
And since this endeavor of ours in asking these questions was preceded by the question or query as to whether there is any embargo on your part to participate in the new process. You said no.
No.
Have you participated otherwise?
No, Lordship. Since I have challenged this particular.
Now, what is the stage of the new process?
Now they have finalized it, Lordship.
You did not
They have not finalized it. They have completed the process.
But you did not participate also.
Lordship. yes.
Why?
I have challenged that fresh NIT, Lordship.
Without prejudice to your rights, you could have. Without prejudice to my rights, if I succeed here, I abandon there. But you are taking a big risk. And with these facts, we don't think we should go into even examine in your case.
Lordship. Lordship, in that case, Lordship, may I pray that, Lordship, since a small issue has to be settled in this case, Lordship, although I may not get the desired result, as your Lordship has rightly pointed out, Lordship, just a small issue, Lordship, for, I mean, this with regards to tree works in hand, Lordship. That issue.
See, these are arguments which you are trying to develop or your
May be settled, Lordship, and then case may be closed, Lordship. Because this particular work in hand, Lordship, which they have pointed out, that has.
See, this is not going to come into effect if you are going to submit your bid for some fresh tender. All bids are independent. This rejection has got nothing, will have nothing to do with your bid which you intend to submit in respect of some other tenders. You have not been blacklisted, nothing of that sort.
Yes, Lordship.
So there is no stigma attached to you.
Lordship.
We can, if you want, we can still give a clarification. This rejection will have no bearing in any manner if you submit your bids in any tender.
No, Lordship, only with regards to that issue, which I'm about to point out, Lordship, with regards to 4 numbers of work, Lordship. Because
Now, what do you get? Suppose we hold that issue has been wrongly decided against you.
Lordship. Just a small prayer.
No, does not make any material because we don't have that much of liberty, neither luxury to.
Lordship.
You can hesitate your grievances.
Lordship.
Heard 3A Tata Planet Council. Oh, so. Otherwise, perhaps you might have had a good case if only your bid was rejected.
Lordship.
And there was a stay order. We might have said that no, we consider before you finalize. In fact, in one case recently in Guwahati, we have said we found that the rejection on technical ground holding to be non-responsive was not proper. And there was a hold on opening the '78, 1978. Third, Sri A. Tatak, Learned Counsel for the petitioner. Also heard you are additional senior advocate. So and so learned additional senior advocate, Arunachal Pradesh for all the respondents.
1 to 4.
1 to
4.
For the official respondents. Full stop. What about the other?
Other initially, they were represented by senior counsel Mukherjee, private respondent.
The private respondent number
private respondent
5 has chosen not to appear. Full stop. Sarah? The case in hand has a checkered history. Full stop. In the year 2019, a work relating to the road network of Kaing Township were eligible for works up to rupees 5 crores, there was objection raised by eligible bidders, including the petitioner, who, however, also participated. Full stop. The aforesaid NITs of the year 2019 were, however, cancelled on 5/8/2019 with an order with a direction for clubbing the said two packages. Full stop. The clubbing of the packages was the subject matter, was unsuccessfully challenged by the petitioner in this court in WPC. Yes?
268, Lordship.
268 of 2019.
Yes, Lordship.
Full stop. Thereafter, the petitioner had participated in the NIT, which was floated on 25/2/2021. Full stop. Along with the petitioner, it appears still bids would be opened. Full stop. Ultimately, on 6/8/2021, all the four bidders, including the petitioner, was held to be technically by a fresh NIT for the work. Full stop. Assailing the aforesaid action, including the initiation of a fresh process, the instant writ petition was filed. Full stop. This court, while issuing notice, had also passed an interim direction not to allot the work, a direction that though the process per se was not stayed, the final orders of allotment should not be issued. Full stop. Para. Sri Tata, the learned counsel, for the one of the interested bidders was a firm, the proprietor of which is the spouse of the local MLA. Full stop. The said firm, the enlistment of the said firm, however, was cancelled on 6/5/2021, and therefore the present action was taken so that the firm gets a further chance to participate in the new bid process. Full stop. By referring to the affidavit in opposition dated 4/1/2022, filed on behalf of the department, comma, the learned counsel for the petitioner has drawn the attention of this court to the averments made in paragraph 3 of the said affidavit in opposition. Full stop. He submits that certain reasons have been cited for cancellation of the bid of the petitioner. Full stop. Amongst those reasons, comma, it has been stated in the affidavit that there were concealment of ongoing projects, comma, there were misrepresentation for which the bid capacity as required under clause 1.4 of section 2 would be affected, comma, there was false representation for which clause 4.5.10 was invoked, and lastly, the PVR submitted was an outdated one. Full stop. The learned counsel submits that none of the reasons are sustainable in law and has been invented only to deprive the petitioner from a fair consideration. Full stop. This court has, however, noticed that it is not only the bid of the petitioner which has been held to be non-responsive, comma, the bid of the other three bidders have also been held to be non-responsive, and reasons thereof are also stated in the said affidavit in opposition. Full stop. Terra. At this stage, comma, the learned additional senior advocate submits that the discretion that the cancellation of the tender of the NIT of the tender process initiated by the NIT dated 25/2/2021 has been done bona fide and for valid grounds. Full stop. He submits that apart from the fact that the administration would have the liberty and discretion to cancel a tender process, comma, such cancellation cannot be matters of judicial review at the instance of an unsuccessful bidder. Full stop. He submits that not only reasons have been assigned for cancellation, for holding the bid of the petitioner to be non-responsive, comma, the bids of the other bidders have also been held to be non-responsive by citing cogent reasons. Full stop. Para. This court is of the view that apart from the settled law that a cancellation of a tender process may not per se be questioned in a petition question in a petition for judicial review, comma, in the instant case, reasons are also assigned for such cancellation, full stop. This court is also of the view that even assuming, for argument's sake, that the petitioner is able to make out a case that the reasons assigned for each ITS, assigned for holding each bid to be non-responsive are held to be unsustainable, comma, there is no challenge by the other bidders with regard to the action of holding their bids also to be non-responsive, full stop. Does, comma, even under such assumption, comma, if a situation arises, a situation may arise where the bid of the petitioner may emerge as the single technically responsive bid, in which case, comma, the CVC guidelines and other procedures would come into application, which calls for a cancellation of the process and to reinitiate a new process. Full stop. Sri Tatak, the learned counsel at this stage, has submitted that the present NIT itself, dated 25/2/2021, was the second time when the works were advertised. Full stop. This court, however, cannot accept, is unable to accept the said submission, inasmuch as though it appears that the NIT dated 25/2/2021 can be construed to be the second attempt, comma, the cancellation of the first attempt was not on a situation of emergence of one single bid, but for other reasons which appears to be bona fide and also been a part of the challenge which was unsuccessfully made by the petitioner in the first round of the litigation. Full stop. Sarah? This court, however, has been informed that the petitioner did not participate in the new NIT dated 25/2/2021, in spite of there being no embargo. Full stop. Sarah? Upon such facts and circumstances, comma, this court is of the opinion that no relief, comma, whatsoever would be entitled to by the petitioner, even if it is held that the rejection of the bid of the petitioner is not in accordance with law. Full stop. Since this court has not gone into the depth of the challenge which the issue of the technical bid of the petitioner, comma, it is however made clear that such rejection of the bid of the petitioner as technically non-responsive would not come into the way for assessing the bid of the petitioner in any future NIT if it intends to participate. Full stop. The writ petition accordingly stands closed.
Deeply honorable.
Lordship, we can open the.
Oh, I'm still closed. The
Technical
interim order,
bits.
the writ petition accordingly stands dismissed. Full stop. The interim order operating is accordingly vacated.
Deeply obliged.
Okay, thank you.